Morning, ladies and gentlemen. I'll call to order the special meeting of the San Francisco Ethics Commission, which has been noticed for today, and the subject matter of which is limited to a discussion of the recommendations of the grand jury report and the Ethics Commission responses to those recommendations. Apologize for the late start. It was our understanding that Chairman Herr would be here, but I will first call the roll. Ms. Hayan, Commissioner Andrews.
Here.
And Commissioner Keene.
Here.
All right, I will call the first item and only item on the agenda. Is discussion and possible action regarding possible commission responses to the 2013-2014 Civil Grand Jury Report, Ethics in the City, Promise, Practice, or Pretense. The Commission's response to the Civil Grand Jury's findings and recommendations is due by August 26, 2014. I will call for public comment.
Commissioners, Ray Hartz, Director, San Francisco Open Government. The last Civil Grand Jury report was the sleeping watchdog. Basically, nothing has changed in the years since that has been issued. I don't see any real reason to believe that there will be any attempt even to change anything from the status quo. Very frankly, I think all of you are appointed by the people who appoint you to protect them and cover their asses, and nothing more. And I say that because on multiple occasions I've come before this commission and made recommendations, and in this Civil Grand Jury report, just as they did in the last one, the Civil Grand Jury spent extensive time and energy making recommendations only to have you thank them very much for their time and tell them to go to hell. That you weren't going to implement any of them, and the reason was you didn't either want to, or the people who appointed you didn't want you to, or you didn't have enough resources. And I guess the question you never seem to want to ask is, are you using the resources you have to good effect? It seems the Civil Grand Jury last time and this time didn't seem to think so. But you disagree. And that's because for some strange reason, the only reason you exist is for your own existence, so that you can provide jobs for the executive director. And I'm not sure what Mr. St. Croix makes a year, 160,000, 180,000? Care to share with us? Apparently not. But they all get very good salaries and very good city benefits, and basically what they do is they rearrange the deck chairs on the Titanic. Nothing changes, and I've asked them repeatedly, give me an example of something you've done in the last 5 years that actually made this a more ethical city. And what we get is what we got when I asked Mr. St. Croix about his salary: silence. And it isn't because of the Sunshine Ordinance saying you don't have to respond, it's because you can't respond. You can't really give us any examples of anything you've done to make this city more ethical. And I'll give you a perfect example is our city librarian, Luis Herrera. A group of us citizens had to take him to the Fair Political Practices Commission in Sacramento to get him to found in violation for 3 years of perjuring himself, accepting thousands of dollars a year from a group called the Friends of the San Francisco Public Library. And the only reason they didn't get him for 7 years is because there was a statute of limitations. And at the same time, he was ignoring his duty to keep an eye on the $60 million they spent between 2000 and 2013, raised in the name of the library, and the city librarian and the library commission have no idea where the money went. So they paid him off to look the other way. And they fined him $200 a year, and he got $5,000 a year worth of benefits. Good deal. I'd like it too.
I'm Bob Planthold. I have what may be the dubious distinction of having been a member both of the Sunshine Ordinance Task Force and of the Ethics Commission. So I want to respond to one of the recommendations which talked about possibly the commission here having a secretary. I'm going to delve into history that none of you were around when I was. Back in the late 1990s, when I was vice chair of the Sunshine Task Force and David Pilpel was the chair, we went to ethics and asked them, can we share a secretary? Because as it is now, there is no budget for the Sunshine Task Force clerk that is squeezed or unfunded mandated time. And we thought, since you folks are supposed to handle referrals from Sunshine for discipline, it makes sense for one person to have the records of both agencies. So that's something you could consider rather than just saying, no, there isn't enough need for one full-time secretary. Be creative. I want to go beyond that, though, to the fact that there's reference to you folks don't have enough staff and resources. That's something we tried for when I was the chair, and before that when I was the vice chair. So at some point, again, be creative. If you don't have the staff and you don't have the resources, just say no. Do a sit-down strike. We're not going to do a half-assed, sloppy job. We're not going to let things pile up. We're not going to run into the possibility that, in some cases, a statute of limitations may apply, because that was what was happening with some of the complaints we had before us, that they'd been pending for so long. Just say no. And if somebody complains and says we're going to charge you, make it a press event how the mayor, each mayor, going back for decades, has throttled, thwarted, choked the Ethics Commission by holding hostage the budget. Don't just accept poverty of resources. Fight back. Thank you.
Good morning. I'm Elena Schmidt. I'm the foreperson of the 2013-2014 Civil Grand Jury. I do want to thank you for having a special meeting to talk about the grand jury report. We put a lot of time into it. I deeply appreciate that you have set aside some special time for it also. It makes a difference. Can I just ask, do you want to hear from the grand jury separately, or is it, am I restricted and other members of the jury restricted to the 3 minutes? How do you want to handle interaction with the grand jury members?
I would be disposed to let you, as a spokesperson for the grand jury. Is that what you're asking?
Yes.
And you'd like more than 3 minutes to play that role?
I can probably do mine in 3 minutes because I just want to give you a quick overview. But I think Rob Van Ravensway, who was the main writer, probably could go longer than 3 minutes. So it depends on how you want to deal with interaction.
I'd be prepared to let him have more time.
Okay. So let me just give a quick overview then, or give you my perspective on the report, since I was the foreperson of the whole jury, and although deeply involved in the ethics aspect of it. So when we began to look at it, our charge is to be the citizens' watchdog of local government. So when we began to look at ethics, we had gotten a citizen's complaint. We began to look around and try to figure out exactly what was going on. The thing that we found that was probably the most interesting was that accountability for ethics and responsibility for holding public servants accountable for their ethical behavior is dispersed. No one has clear ultimate responsibility. The Ethics Commission has some responsibility for holding public servants accountable. The mayor has some responsibility. The city attorney has some responsibility. Sunshine Task Force has some responsibility. So it's dispersed. And you all understand that when it gets dispersed and no one is ultimately accountable, there's only so much each group can do. And so part of why we are emphasizing a number of the comments is to make sure that everybody begins to understand what their accountability is and that they coordinate with each other to make sure. What we also found is with that dispersion of responsibility, there was the culture within the government of San Francisco that basically allowed ethics to be a second priority. It wasn't the top priority. They were going to do whatever they could do, anybody, to not be held accountable for their behavior. And certainly the accountability, the transparency with ethics is what's important for you especially to keep in mind. But that's what the citizens have asked for. You know, the citizens of San Francisco have, over a number of years, agreed to proposals, put initiatives forward to say, ethical behavior, ethical behavior, ethical behavior. We want it. That's really what we're after. And so as we look at that as the past and we look at the future and what's the future going to be with all the court decisions that have come out, with all the public dollars that are being flowed into the private, all the private dollars that are being flowed into the public arena, you all have a responsibility to look and to examine the laws, to see what's going on and what's effective, what's not effective, and that you all have to begin to anticipate what should be going forward in order to keep track of and to have transparency in the private dollars that are coming into the public arena. One of the things that we all do as grand jurors is we bring our past experiences to the work that we're doing. And my experience that I brought especially to this particular endeavor is that I had worked for both the Public Utilities Commission and for the Energy Commission. So I've had the experience of dealing with very strong commissions, and it makes a huge difference in public policy. And that as the commission steps up and deals with the policy issues that are out there, begins to define policy when it comes to ethical behavior, it can make a difference. And so we made some recommendations about that you begin to see yourselves as a policy-making body, not just an implementation body, that you begin to meet as committees so that you can keep track of the bigger issues that are happening, the implementation questions that are out there. We talked about a hearing officer, especially for the Sunshine Task Force, so that there could be some historic record that's being kept, and so that, again, a level of professionalism could come forward that would mean that a record was being kept and they could build off the history that they have. I'm going to let Rob, if you would, allow Rob Von Zwijnenweg to go through the report a little bit more of a detail and be happy to answer your questions. Again, thanks for your time on this.
Thank you.
Can I suggest that we finish public comment and then invite Mr. Van Ravensway
I think
outside of public comment to address
I was going to make that same suggestion, is that if we've got public comment that is not specifically directed toward the grand jury participants, let's hear that, and then we will get into the more details, so that, because there may well be some interchange between commissioners and the speaker. Go ahead.
Good morning, members of the Ethics Commission. I want to make 3 points about this report. First, my name is Quentin Kopp. I am, of course, a resident of the city and county of San Francisco, and I have been a participant and an observer of local government for about 56 years and counting. I served for 2.5 years as the grand jury presiding judge of the San Mateo County civil grand juries 11, 12, 13 years ago. I've read a lot of grand jury reports. The first point is this is probably as well written, well analyzed as any grand jury committee report and grand jury report as I've ever seen. If you haven't read it, it's understandable reading. Don't be deterred by the length. Secondly, I opposed the creation of this commission, as history records, because there was a day when the city attorney and the district attorney's offices, between them, policed the ethical and unethical behavior of local public officials in San Francisco. It's an unnecessary commission with a budget of a little over $2 million, which could either be conserved or transferred to the city attorney or district attorney's office. The district attorney has supposedly some office called the Public Integrity Section, which I think announced a couple of two-bit cases during the last fiscal year, 2013 and 2014. But that's the repository and should be the repository of enforcement of laws. Secondly, or thirdly, and lastly, the essential recommendation of this report is get out of business. Transferred to the Fair Political Practices Commission of the State of California the responsibilities of this Ethics Commission. I urge you to act in ways to implement that recommendation.
Thank you.
Good morning, Thomas Piccarello. I want to compliment the grand jury for the report. It's an excellent report. It seems that ethics in the city is all pretense and no practice. I strongly urge you to follow the recommendations of the grand jury report. I briefly looked at your draft response, and it's a total ignoring of the recommendations of the grand jury. I strongly ask you to modify your draft and adopt most of the recommendations by the grand jury. Thank you.
Any other public comment before we get to the gentleman from the grand jury?
Good morning.
Morning.
I'm Robert Van Ravensway. I was the primary author of this report. I was the deputy foreperson of the grand jury as well. It's a lengthy report, and I'm going to try and sum up what we're driving at with a lot of the recommendations and findings of the report. In analyzing the situation with the Ethics Commission, and I think some of the points have been made by some of the other public speakers and by Elena, we see this kind of diffuse responsibility for enforcement, and we feel that the best enforcement tools, in large part, lie with other entities, whether it's the district attorney or the state. And we feel that the Ethics Commission, both at the staff level and at the commission level, should be more engaged in encouraging transparency in government. You have a large operation geared towards transparency right now. We note some potential problem areas, but we think that's really the big thrust of what you should be doing. And with the commission itself, we really would like to emphasize the importance of forward-looking on policy. And we emphasize a report that has not been prepared in recent years, possibly never, analyzing the shortcomings or the effectiveness of the various laws that you administer, which we think is a wonderful vehicle both to educate the public and to educate yourself as to what's going on in the overall environment with campaign finance, government ethics, and things of that nature. Now, we addressed findings and recommendations both to the commission and to the executive director. Some just to the commission, some just to the executive director, many to both. Because we see different roles for the commission and for the executive director. We see the commission as a policy body. Sometimes you can be legislative, where you propose changes in the laws. Sometimes you're judicial, in a sense. But you're more, you have this broader policy role, where the staff is administering these laws and dealing with things on a day-to-day basis. And so we would expect the viewpoints on some of these matters to be a little bit different, when you're taking a broad view versus dealing with day-to-day problems. And in terms of some of our proposals, we really aim to sort of get the minutia away from the commission and to make your life easier in some ways in terms of letting you focus on these broader policy issues. So we recommend things like having an independent hearing officer on the Sunshine Task Force complaints so that you get a more complete record, so you can act a little more directly when you get it, to have a commission secretary to sort of interface between you and the public, to organize your agendas in a different fashion, to potentially get your own attorney separate from the city attorney, and to potentially work through committees a little bit more so that some members can focus on some topics more than others, and when the full commission is meeting, you can get a more developed narrative on certain policy issues. We also recommend moving major enforcement actions to the FPPC because we think it's important to get away from potential influence by people in the city. It just doesn't make sense to have the people that are setting your budget in one form or another be the people that you're trying to enforce laws against. So that's sort of the general thrust. I can speak to individual items, but that's sort of what we're trying to accomplish with the report.
Do the commissioners have any questions, gentlemen? Go ahead, Mr. Keene.
Mr. Chair, I wonder if, as we later on go through our discussion of our response to the grand jury, whether at that time we can just call Mr. von Ravensburg and ask him about various things that are in it, because I have a number of things that would I could use his help on in regard, rather than bombard him with a bunch of questions now. Put them.
I think that's a good suggestion, but what I would say is, as we go through the responses, the draft responses, one at a time, I think probably under the rules, I have to ask for public comment each time, and I want to hopefully limit the public comment to somebody who specifically wants to address that particular recommendation rather than some general comment about how ineffective this commission is and how we're just a bunch of hired hands by the politicians in San Francisco, but limiting that discussion to the very issue, and I would so I will encourage at least the two members of the grand jury that were here, if they would hopefully respond as we come to each one, as if you've got some, if the commissioners have some questions that they want to ask.
I'd be happy to answer further questions.
Thank you.
I do have a
Commissioner
general.
Hayden?
I do have a general comment. First of all, I'd like to echo what has been said earlier, that it's a very, very well-written and understandable document. And I really appreciate the thoughtfulness and the time and effort that went into this. I think that you took your job very seriously, and I think that we need to pay attention to your recommendations. We may not agree with all of them, with each and every single one, but I think all of them need to be discussed and looked at. So I appreciate your effort. Thank you very much.
Thank you, Commissioner.
Mr. Chair.
Any other public comment? Commissioner Keene?
Yeah, I just wanted to echo what Ms. Hayon has said as well in regard to the report itself. I think the report is an excellent document, shows a lot of work, and as Senator Kopp said, it's highly readable, highly understandable, and is very much an set of instructions that many of which we should follow. In regard to the civil grand jury's role generally, during the course of my career, having been an assistant department head of a city department for 20 years, there were 2 times during that period that my department was the subject of civil grand jury reports. And each time, I think each department is looked at by the civil grand jury, there are a couple of responses that sort of instinctively occur. One is that there's a defensiveness that automatically takes place. They're criticizing us, they're after us, we're bad, they're saying we're bad, therefore we have to respond in some way to show that they're wrong. I think that is a totally unproductive way to address something like the civil grand jury's efforts in any situation, and certainly in this situation. And that's certainly not the way I'm going to address it when I go forward. And in regard to some of the comments that were made, just preliminary, relating to our proposed draft, I agree with those comments that the draft itself, I'm going to ask that it be substantially modified, that there is in the proposed draft some of that syndrome that I talked about, to just be defensive and to take on the grand jury about specific things that the grand jury is being said. That's totally unhelpful. I think, and I'm sure my colleagues will agree, that as we go through your recommendations, much of your recommendations are things that we can agree on and should agree on. Other things we'll have some discussion about the manner in which we should agree on it. But for the most part, I want to commend all of you for your work. Your work is outstanding. The citizens of San Francisco owe you a great debt, and I, as a member of this commission, and I'm sure my other colleagues, appreciate it very much.
Good morning, Commissioners. I'm Richard Nee, a former member of the Sunshine Ordinance Task Force, on which I had the privilege of serving 12 years. Recently, my replacement was finally appointed. A few things. First of all, on your response to finding recommendation number 12, you say the Ethics Commission Director will have staff notifies all departments to remind officials and employees to follow the record posting requirement, ensure that such postings are easy to locate on departmental websites. Now, what's the or else there? I mean, you're going to have your your staff notify the department heads to follow the posting requirement, but what if they don't? You know, what's the or else there? On recommendation, on your response to recommendation number 20B, the appointment of an independent hearing officer, you point out that there's no mechanism in the Sunshine Ordinance to do this, but I would encourage you to consult with the city attorney. There might be nothing to prohibit it. And in that being the case, it's certainly worth examining. Finally, going back to your response to finding 1F, where you say the budget process is the primary attachment of the Ethics Commission to the city. Maybe it is, but there's also the appointment process. Each of you is appointed by somebody in the city, as by an elected city official, you know, whom the commission is duty-bound to whose activities the commission is duty-bound to oversee to a certain extent. There's an attachment.
Any other public comment? All right. Hearing none, I will Commissioner Keene, you made some strong comments that you disagreed with parts of this draft recommendation, so I guess we will start with the recommendation in response to the findings and recommendation number 1. Do you or any other commissioners have any comments, suggested changes?
I have, yeah, Mr. Chair, yes.
Go ahead.
The finding is that the Ethics Commission, the finding by the grand jury is that the Ethics Commission lacks resources to handle major enforcement cases. And then it goes on to include sort of examples of a number of cases, misconduct, et cetera. And Mr. Chair, I would strongly recommend that we not use the language in our response where, as to that finding number 1, where we say we disagree. And for one thing, what we've been saying many times in regard to this commission and this commission's resources and ability to handle many of the things that we want to handle, we are hamstrung because of the lack of resources. And in regard to where we respond to this finding, it's almost like someone is living in a parallel world rather than addressing something different from what has been the experience of this commission and what this commission has been saying all along. Where, first of all, it says the grand jury cited no instances where there are alleged charges of misconduct, conflict of interest, et cetera, where the Ethics Commission failed to act due to a lack of resources. I think it's irrelevant whether or not the grand jury cited any specifics or came up with any kind of specifics, or that there's any sort of burden of proof on their part to come up and tell us about specific cases where we failed to do something we should have done. We generally acknowledge among ourselves at each of our meetings that we need more investigators, we need more staff, we need more resources. So rather than to say in our findings we disagree and then to take the grand jury to task for saying, well, you haven't cited any specific cases where we haven't done our job, I would ask that we agree with them and change it to and say that the Ethics Commission lacks sufficient resources to handle to handle its work, and I would just stop there rather than going into any of these things having to do with specifics and trying to split hairs relating to the type of cases that can be handled and can't be handled. But for us to say anything other than the fact that we don't have sufficient resources, I think would be disingenuous and would also be against our own interests at the time, at budget time, when we approach the city and ask them for resources. So if I can put it in the form of a motion, we can vote on them later on, but I would just move that in regard to our response to it, finding 1A, that we agree to the extent that the Ethics Commission lacks sufficient resources to handle all of its work. And I would do that as to recommendation 1A. Now, should I continue with the rest of my observations on one, Mr. Chair?
Well, your comments were specifically, I think, directed to how we respond to the recommendation.
Yeah.
And the recommendation reads, the jury recommends a contract with the Fair Political Practices Commission.
No. I'm sorry. I don't mean to interrupt the chair, but where my comments relate to where it says right about 2/3 of the way down the page, finding as to 1A, and 1A is that first paragraph up at the top.
All right.
Where the grand jury is saying the Ethics Commission lacks sufficient resources to handle major enforcement cases, et cetera. Our response to that language, according to our draft, is finding as to 1A that we lack, is we disagree. And then we go on to take them to task for saying, well, you haven't shown any specific types of situations where we have not been able to handle these cases. If we're going to have a response to finding 1A, as we now have in the draft, it should not be that language that's there. The language should be, we agree that the Ethics Commission lacks sufficient resources to fully handle its job.
But that's not what the finding 1A is. It isn't that we lack resources. It's we lack resources specifically to enforce, to handle major enforcement cases. And that's where I think the disagreement is. There's no disagreement that we need more resources. But it isn't, I'm asking, and my concern is that I'm not ready to concede that since I've been on the commission, that we have refused to handle any major enforcement case involving misconduct, conflict of interest, violating campaign financing and lobbying laws because we didn't have the resources.
And Mr. Chair, I don't think that's what finding 1A says. Finding 1A does not accuse us of not handling those specific cases that are talked about. It says that we lack sufficient resources to handle major enforcement cases. That's a global statement as to whether or not we have the sufficient resources. And then it goes on as examples to include those, what types of cases they're talking about: alleged misconduct, conflict of interest, violating campaign financing and lobbying laws, and violating post-employment restrictions. That language does not say we haven't done our job in handling those cases. As I read it, it just says we don't have sufficient resources to adequately handle it. It doesn't say we've ducked any or that we've let any go by the boards. We may have, I don't know, but it is just saying that in terms of the resources we have now, they're not sufficient to handle our work generally, and our work generally includes those specific matters that are also listed. I think we should agree with that. And if for nothing else, it gives us ammunition to approach our budget with the city in regard to saying that we need more resources in order to effectively handle these cases.
Any of the other commissioners have any comments on that?
Chair. So I think later in the In the report, we do mention the fact that there is one unfunded investigator, I believe. And it is specifically because we lack the resources to hire that other investigator. So in many ways it could fly. Both of them can't be true. So either we do lack the resources or we don't lack the resources. And I believe there is an open position of an investigator or an auditor. I remember reading in the report, and it is specifically because there isn't funding to support that. So that said, I think we do lack the resources. And I guess the question would be, there is an way in which you do business. If you're saying to me that in your org chart all of your positions are filled, what you're stating to the city and to the public is that you are running at optimum level. But if your org chart is missing a position and it's vacant because it's underfunded, and I think that's what we have here, then I think we do lack the resources. Now, how that's written in our response, I think we still will need to talk about that. But the fact is that there is an open position.
Commissioner Hagan?
Where to begin? I guess one way to address the grand jury report is to go through each single finding and each single recommendation line by line. That's fine. I'm not opposed to that. But I would just like to remind my fellow commissioners that I think that there are much larger policy issues that have been recommended here that we need to address. So whether or not we agree that we lack resources or don't lack resources, I don't think is the important issue that we really need to address and that the grand jury has really brought before us. They're making some very strong recommendations about how we should handle policy, how we should work with other agencies, and whether or not we should even exist or be doing the bulk of the work that is assigned to us. And I think those are major issues that we need to discuss thoroughly, and we can certainly go line by line, but I personally would like to put my energy into the much larger policy issues that have been recommended here.
Yes.
My name is Larry Bush. I'm a member of the civil grand jury that worked on this report, and so I'm speaking in this capacity, specifically to finding 1A. The first point is that it only refers to resources. It doesn't refer to financial resources. And it's true that you have lacked legal resources to do some of the things you wanted. For example, when you made a finding of misconduct on the part of the Library Commission president, you said you lacked the resources legally for the commission to take action against a commissioner, that only a department head but not commissioners could be under the purview of the commission. So there is an example of a legal resource that you did not have to act on a conflict of interest, or in that case, a Sunshine Ordinance violation. Secondly, if you go back through your records, you will see that for 2 years, the Ethics Commission Executive Director sent out letters saying that they would not do any follow-up on Form 700 filings, saying there was not sufficient resources to follow up and contact each of the non-filers with the fact that they had not filed their Form 700s. That was for 2 years. Thirdly, there was also a letter that went out to all department heads saying that you no longer needed to provide the Ethics Commission with reports on contracts that had been signed, which is an important conflict of interest issue, but that there was insufficient resources at the Commission to review those things. So the Commission's own record says you lacked sufficient resources to do the jobs that had been assigned to you by the voters.
Thank you.
I'm Bob Planthold. Because Commissioner Peter Keene has focused on finding 1A, I wanted to indicate that there may be instances where there's a failure to timely follow up on complaints. But because of the confidentiality of complaints lodged with you, I don't know to what extent a grand jury would have been able to see those. This doesn't indicate whether they saw complaints. But the public also is told when you file a complaint not to make it public. So here's the situation. I did file, within the term of this grand jury, a complaint of official misconduct. Other complaints I've filed have normally had some answer. We're going to investigate. We don't think it's worthwhile. We're referring it to FPPC. Other complaints have had a response within 2 months or less. This one, no. And so it raises the question, do you have enough resources? And it's official misconduct. It also allows some of the thoughts of people who say there's politics involved. This person is subject to your jurisdiction and is very influential within city government. But if I'd been asked by the grand jury, from my experience about filing complaints, I wouldn't know if I'd been able to tell them about this complaint of official misconduct. I don't know what they're able to see. But the very fact there's a longer than normal timeline and a lack of response makes me question whether there is an adequacy of resources to specifically say this has merit, this is unfounded, this is somebody else's jurisdiction, or this should be sent somewhere else. So that they didn't cite anything doesn't mean that there aren't situations where something wasn't handled in what has previously been, according to normal practice, a timeline of response.
Commissioner Keene?
Mr. Chair, just following up on what the speaker said, I think he makes a very good point in regard to what I had indicated, that for us in our language to the grand jury to essentially tell them in a rather petulant way, well, you haven't shown us, give us a list, chapter and verse, of all sorts of situations that we should have taken on and done, which we didn't. Or else you're wrong about us not having resources, is, I think, not only an unseemly way to react to, in our language, to what they're saying, but it's kind of juvenile. And it's that kind of petulant defensiveness that I talked about a little while ago that sometimes is engendered by where people feel that they've been put personally under attack. How is the public to know what we haven't done? And how is the public to prove to us that we haven't done something? When much of the many aspects of the process itself, as was indicated itself by the speaker, the public isn't allowed to be aware of, because if there's going to be some public complaint against someone, the complaint can be compromised to begin with if it is made public. So definitely, whatever we do, I think, just for our own sense of self-worth, we should delete that language in our response where we're telling the grand jury, you haven't proved your case to us. Tell us about some actions. I don't know why that language is in there, and I think that language kind of puts us in a very unfortunate light.
You want to make a motion that we
Yes.
redraft that? And
Yes, I do. And my motion would follow up on what I had said before, that in regard to that paragraph that we have where it says findings as to 1A and it says disagree and then goes on to chastise the grand jury for not citing specifics, I would take that whole thing out and just put in as our response to that, we agree that the Ethics Commission lacks sufficient resources to handle much of its work. And if it's necessary to, as the chair indicated, it feels to specifically address those specifics that the grand jury puts there as an example, put that language in. Sufficient resources to handle much of its work, which includes major enforcement cases, alleging misconduct, conflict of interest, and the rest of that language in the paragraph.
What about the last sentence in that finding 1A? You want that deleted?
No, I'd leave that in there. I think that's appropriate in terms of the commission saying, while the Ethics Commission, like many agencies, does not have full resources, once again, just that language itself contradicts what the earlier language saying that we're doing fine. We got plenty of money. We got plenty of resources. Put that back, leave that in. While the Ethics Commission, like many agencies, does not have the full resources it could use in carrying out its mission, it is productive in resolving its enforcement cases, because I think the commission, the staff, is productive and does a good job to the extent that it can.
So you want to just strike the first sentence?
Yeah, strike the first sentence and
strike the disagree?
Strike disagree and put in agree.
While the Ethics Commission.
I'm going to allow, defer to Commissioner Aon.
I'm going to read what this, with the second sentence. The findings 1A, our response. While the Ethics Commission acknowledges, like many agencies, that it does not have the full resources, et cetera, and just just have that sentence. Does that make sense to all of you?
So you're saying agree, and then that statement.
Well, I don't know. Are we going to use the words agree or disagree?
We have to.
We have to. Okay. So agree, and then use that. Then use followed by that sentence. Again, while the Ethics Commission acknowledges, like many agencies, that it does not have full resources, et cetera, et cetera.
Right.
I'd accept that as
okay.
Part of the motion, as the motion.
Okay.
So your motion is as read by Commissioner Hayen, and I assume you are seconding it?
I am, yes.
All right. Any public comment on that particular? Yes.
I have not submitted anything. Well, I have something presented to the Ethics Commission of trying to get a records. And when the others saw, the people that should respond said they agreed with me and they would respond, they never responded. Well, does that mean I have to come back and get nothing done? It seems to me that some action can be taken short of a full investigation, maybe a referral to some other agency that you can say, we don't have staff to do this, but we think the district attorney should investigate. But the two things that I have brought that I put a lot of work into presenting a cognizable case, one was to the grand jury of Alameda County. They made a pitch to the public, submit your complaints about government so we can get something done. I did not get any acknowledgement. I found that other people had gotten acknowledgments. But when I investigated the process, it seemed the complaints that are addressed to the grand jury were first submitted to the district attorney. And the complaint that I made was very severe about the transportation agency and corruption there. And party was involved, and the agency that was corrupt was the same party as the district attorney, and it would reflect on their ability to get collections if the identification were made. So it's a difficult thing to figure out how to protect confidence and how to make a cognizable case that it isn't a political corruption that is holding up the enforcement. I've gotten a similar kind of situation of providing data that took a lot of investigation on my part, which I felt I could do better in the first line of presenting things than the enforcement agency, because I wasn't in direct controversy with them, and they couldn't make this pitch that I was fighting them. I was asking them for disclosure and consistency of their actions. So I think that it's worth putting a lot of attention on a good process for getting the laws enforced rather than excuses for not doing anything.
Thank you very much. We have the motion pending. Yes?
Commissioners, Ray Hartz, Director, San Francisco Open Government. I want to thank Commissioner Keene and Commissioner Andrews because this is a kind of a breath of fresh air. I think that the tone of the letter is typical of what we usually see, which is a very defensive and very argumentative thing, which seemed to be, let's find fault with the grand jury, and that way people will be discouraged from looking at us directly. I do think that the phrasing of these all has to be carefully considered. Given the fact that you are limited in your resources, everybody is limited in their resources. Nobody has as much as they would like. The question is, what do you do with those resources? And I go to Commissioner Haon's comment, which is, you're a policy body, and it is your policy that determines what the staff does with the resources they have. And the question I would like to see discussed, especially when we get into some of these other matters, is whether or not the resources that you have could be reallocated to respond more appropriately to some of these recommendations from the civil grand jury. In other words, you don't have to be doing badly to do better. And the question is not, can we find some justification for explaining away what the grand jury says, but can we find a way of taking what they have given us and implementing it to whatever degree we may be able to, including reallocating resources in that effort.
Thomas Piccarello again. First, let me say, I'm troubled, though, by the chair of this commission not being here today for this very important discussion. This hearing was noticed, especially, and it shouldn't have been noticed without the chair of this commission. So I'm disappointed in that regard, and I think his absence sends a message as to what your responses are going to be today. I strongly support the motion by Commissioner Keene. You should fully agree with the recommendations and advise the Commission that you're mandated under Penal Code 933.05 as to the proper responses. You have to agree or disagree or partially disagree or partially agree. In addition, there's other requirements. So if you look on page 2 of the grand jury report, you will see how you are supposed to respond to this report pursuant to Penal Code 933.05. Thank you.
Thank you. All right. I will call the motion. All in favor?
Aye.
Aye. Opposed? Motion is carried unanimously. Response to finding 1A will be modified as set forth in the motion. Now, there's been, Commissioner Haon has raised the question of whether or not we're going to fly-spec every sentence that is in this response, in which case we may be here a long time, and I'm perfectly willing to let us do that if that's what the commissioners want to do, or whether we ought to turn to what may be sort of the key recommendations that I think the public is concerned that we ought to address. But I will follow the wishes of the commissioners.
Well, Mr. Chair, unless we're going to just jettison the entire, our entire response and then go ahead and formulate a response based upon what we think are the major policy questions that we want to talk about, which I wouldn't have any problem with if we just jettisoned the response that we have in this draft. I think that if we don't do that, then unfortunately, there's a lot of language in here that I just feel I have to take on, and that the commission should take on, because there's a lot of it that's simply inappropriate, and I don't think we've put it out now as a proposed draft, and certainly I wouldn't want to adopt the rest of it without addressing some of the things that I have. I've got maybe a half a dozen things to point out. It's not really it is fly specking.
Well, and I appreciate that, but I think we're mandated to respond to the findings and to the recommendations, and we're mandated to do it by a certain date. And I believe the draft has been out for some time, and comments could have been made at that point, but in order to get a final draft out, there's got to be at least 3 of us who agree that we're prepared to say this is the letter that goes to the Superior Court judge, being our mandated response. So I'll do it whichever way we all feel comfortable with.
Well, despite my desire to do more big picture discussion, I acknowledge that we, in a sense, we don't have a choice but to go through the language, but perhaps there's a way to just go through each one and find out who has any objections or wants to change the language or disagrees with what has been included. So if we can do that efficiently, that would be great.
All right, well, what I would propose to do is let's go through the total number 1 findings recommendation, resolve that one, and although I may not be required to do it, I would choose to get public comment before we vote on the entire body of 1 and go through each one of them.
Okay.
So you started on 1A. Does anybody have any other comments that goes down through the recommendation?
Yes, Mr. Chair, I have a comment in regard to finding 1C down at the bottom. Once again, the language there having to do with confidentiality, I agree that we have a problem relating to confidentiality, and we can't just discard the confidentiality requirements. But my argument would be with that last sentence, which again I think is kind of gratuitously taking a shot at the grand jury, and it really it's not very logical either. Where we go ahead and justify certain actions that we cannot take because of our confidential requirements. We add that last language. The Commission notes that the civil grand jury also operates in complete confidentiality. That's an apple and an orange. I mean, in regard to the confidentiality requirements that we have some very specific confidentiality requirements in the code itself. To say that whatever our confidentiality requirements are justified because the civil grand jury operates in complete confidentiality. The whole history of grand juries and the way grand juries do things is much different from to attempt to equate the work of a grand jury with a city commission and the appropriateness of the way grand juries have conducted themselves going back to the Magna Carta in secrecy and in confidentiality for us to therefore use that as a justification, I think is a little bit grandiose, and it's not comparing two things, that our confidentiality is okay, because, look, grand juries operate with confidentiality. So I just moved to strike that sentence where it says the commission notes that the civil grand jury also operates in complete confidentiality. It's a gratuitous comment that says nothing.
But anything else on finding 1 and recommendation 1?
No, that would be extent of my specific comments to the language in finding 1 and in number 1, Mr. Chair.
Any commissioners have any other proposed amendments to number 1? As amended, I take it you move that we adopt the response to findings and recommendation number 1 with the deletion of that sentence?
Yes.
Have a second?
Second.
All those in favor?
Aye.
Aye.
Public comment.
No, I said aye, not on that.
When you have a motion, you have to have public.
Does anybody want to comment on that? On our taking it out?
I thought you were going to ask us to comment on all of 1.
All right.
Anything else?
Go ahead.
1F has to do with the FPPC. And our investigation from the civil grand jury is that the FPPC is prepared to accept a contract from the City of San Francisco to enforce not only state but also local laws. That they have that same authority in some other jurisdictions, and they are open to a suggestion from the Board of Supervisors to create a similar arrangement for San Francisco. So this statement says that it's possible the charter would prohibit such a contract. There's nothing in that statement that substantiates that. There's just a statement that it's possible. There's nobody from the city attorney's office saying that that's true. It says that it's not allowed under state law. That's not what the FPPC told the civil grand jury when we met with officials who we will not name because of our confidentiality, but we can tell you that they were authoritative figures, and that it's not simply the county of San Bernardino, but other counties as well that have that authority. Thank you.
Any other public comment? With the motion, it's been seconded. All in favor, say aye.
Aye.
Aye. Opposed? All right. Findings in response to findings and recommendation number 1 approved unanimously. Turn to finding number 2 and the recommendation. Do any commissioner have any comment on the draft language as to finding number 2?
I have some questions, Mr. Chair, and if I may put them to Mr. Von Ravensway. In regard to number 2, the grand jury talks about improper campaign contributions that were returned to the contributor rather than forfeited to the city, as required by city law. Could you tell us what those were?
I believe there's a number of instances. We were thinking specifically of some money laundering situations where actually cases have been brought by other entities, but the campaign contributions were returned.
So the campaign contributions were returned, but there was no action by this commission waiving the forfeiture and saying that they could be returned?
None that we found, no. I do want to note, finding 2 and recommendation 2, we did not call for a response by the Ethics Commission on this particular item. And there are some other items in this draft. Findings and recommendation number 7 and number 18.
Number
Also-
7 and 18, did you say?
Yeah, we also did not call for a commission response on.
Is there some reason why you didn't want a response to that? I mean, I don't.
You know, on this one, we're calling for an audit by the city attorney.
Okay.
You know, for example.
Because just as one as one member of this commission, I'd like to be educated in regard to those activities where if the commission did act wrongfully and failed to do its duty to.
We didn't find any action by the commission at all on these particular matters.
Did you find anything?
These were things that are basically reported in the press. You know, they clearly were situations like in money laundering, you know, where you have an employer reimbursing employees for campaign contributions, where the campaigns would say, oh, we return the contributions.
Did you find anything about the commission knowing of those things before the money was returned, or?
I can't say.
You can't say because of confidentiality, or you just don't know? Or?
I don't know.
Okay. All right. I'm satisfied then.
Is there a motion that the commission adopt response to finding 2 and the recommendation?
I'm going to leave it the way it is. You don't need a motion. You
Okay.
can just move on.
All right, I've been advised that we don't need a motion because we aren't changing it, and we're just going to adopt at the end for all of those where we didn't make a change. We'll make a general motion to adopt everything after all the changes are made.
Well, Mr. Chair, I hate to be a dog in the manger here, but we do have language that we're giving back to the grand jury, even though we're not required to make a recommendation. If we want to take that language out, that's fine with me. But we do respond, and we say there's this kind of mystical response in terms of it has been commission policy since August that if a committee returns a corporate or excess contribution to the donor prior to any action taken by the commission, the return contribution is not subject to forfeiture. This clearly falls under the authority that the Ethics Commission may provide for the waiver or reduction of the forfeiture. It's almost like we're responding and saying, this thing that you've told us about, it was okay for us to do that because someone gave it back and we had the power to waive it. I move that we just take that language out in our response. Since they're not asking for a response, and I don't know what the heck that even says.
Are you saying that just based on what you've been told that the grand jury didn't ask us to respond to finding number 2 and recommendation number 2, that we just eliminate that?
Just eliminate it, yes.
Well, I would say either eliminate it or respond more directly, which is we would either say we agree and would make a recommendation to the Board of Supervisors to request an independent audit by the city attorney, or we disagree that we will not make a recommendation. So one of the two, I think, could.
I'd adopt Commissioner Andrews' first recommendation that we agree, and we ask that, because if this has been done and money has gone back, which should have been forfeited and was illegal, instead illegally went to someone other than going to the city, which should get that money, that should be found out about. That should be exposed. So I would agree with Commissioner Anders that we agree with the city attorney that the Board of Supervisors request an independent audit to see whether or not any of those things have happened.
Can I say something?
You want to comment?
I don't know the case that the grand jury is talking about, but I suspect...
He says he's not talking about it.
I suspect that it is a case that was handled by the district attorney, not the Ethics Commission.
But
the law does allow us to waive or reduced certain forfeitures.
I'm-
And we have, when candidates and campaigns accept illegal contributions and they bring it to our attention before we find it, we have allowed them to return the contribution rather than forfeit.
Mr. St. Croix, what you're saying doesn't make any sense in the context of our discussion, because in regard to my question, is there a particular case, does he know of any particular cases? And he said no, he doesn't know of any. You've got something in mind, obviously, but it was not the same thing that the grand jury had in mind. So the fact that we're going to respond to something that you know about, that you have in mind,
Well,
doesn't make any sense. We got to respond to what the grand jury is asking us. And
well, in that case, I would request that the commissioners just eliminate the response entirely.
I agree. Well, no, I agree with that, but also add the language that Commissioner Andrews has suggested, that there be an audit, that if there are any of those improper actions that have occurred where the money has gone back, that it be found out about. And
I guess the difficulty I have is that, as I understand what's being said, they weren't improper because the commission had not acted, and so there was discretion. That rather than being forfeited the city, the forfeiture is waived, so that it's not that there's something done illegally, as I understand what's being said. I think I would prefer, at least from my point of view, that we just not respond. If the grand jury didn't ask us to respond, that we not respond and let the district attorney respond however he may wish.
Well, here's finding two. I would amend it and say the commission, to our knowledge, doesn't know of any improper campaign contributions, but agrees with the recommendation that an independent audit by the city attorney be conducted.
I'd accept that language as part of the motion.
Excuse me.
So I move.
Make your motion specifically so that.
So I move that we remove the current response and replace it with a response that while the commission does not have knowledge of any improper campaign contributions, we do recommend the Board of Supervisors request an independent audit by the city attorney.
Second.
All right. Public comment on the proposed.
I'm Bob Plantold. I like the fact that you're frankly going to amend this and get rid of what seems clearly convoluted draft response. I want to suggest that it might be worth the commission in the future considering getting an education and revisiting the August 2008 policy decision. And here's why. In the draft wording, it seems inconsistent that you say, prior to any action taken by the commission, and then you say the commission may provide for the waiver or reduction. It seems like if staff knows about it, but the commission hasn't had it on their agenda, it can be returned. There's the problem here that when I was on the commission, we were given to understand the way the wording of setting up the Ethics Commission, there's not a distinction between the actual commission, you folks, and staff. So the public doesn't necessarily know that sometimes staff have authority to do things in the name of the commission. And that's where I think right here you're talking about in your draft, prior to any action taken by the commission, but you say the commission may provide. That's an active verb, that the commission's going to provide for a waiver, a specific decision. This doesn't seem to say following the blanket policy adopted in August 2008, but a specific decision. There's inconsistency in the language. You're wanting to get rid of it. I'm saying good. but please consider revisiting that August 2008 policy and whatever circumstance, situation, case presented itself so that you get a better understanding and then can better deal with any possible audit. Thank you.
Any other public comment?
Larry Bush from the Civil Grand Jury again. The August agenda and minutes show that there was never a vote taken on a policy like this. However, there was a memo from the staff to the Commission in March of 2008, which outlined a series of policy statements. One of the policy statements was that were there an inadvertent acceptance of contributions that exceeded what the law allowed and that money was returned, there would not be a forfeiture, but there would have to be a signed stipulation from the committee or the candidate saying they had accepted a contribution which was not legally acceptable. We found no record of any signed stipulations from any candidate or any committee as required. And we might further state that that policy was to remain in effect until a majority of the commission overturned it. I don't believe it's ever been reviewed since March of 2008. There are a number of other things in it, and I would point out that it was a policy statement and not a regulation, and so therefore it never went to the Board of Supervisors. It was entirely in-house. I suggest that, as Mr. Plantholt just said, that you revisit the entire policy and see if that's something you want to take a look at.
Thank you.
Commissioners, Ray Hartz, Director, San Francisco Open Government. I totally agree with both of the prior speakers. Any kind of a waiver that is done should be a positive action. It should be something where the facts are considered and the commission actually considers it in open where anybody in the public can come and hear the comments and the discussion and make comment themselves and then be done. And this basically, if you read this recommendation, it's an admission that we've done this in the past. And it's also an admission that this has just been our blanket policy. And that's not the way these things should be done because it leaves basically what it is I'm a corporate attorney and I say, well, let's give a donation, and if somebody catches us or if the person who gets the donation realizes that it's wrong, then we'll just take it back. There's no penalty. And as a result, it really just drops the bar to so it's just such a low level that anybody can do it and suffer no consequences. And it really is ridiculous. These kinds of things, now I can understand if you have a small campaign, Granny Gray decides to run for the Board of Supervisors and she makes an illegal contribution because the laws are complicated, and you have a hearing and say it wasn't intentional, it wasn't willful, and she didn't have the resources to really understand what she was doing and that what she was doing is wrong, let us waive that. I can understand that and agree with it wholly. But we're talking about, in the majority of cases, big corporate donations. As the members of the grand jury said, instances where a company says, okay, you donate the money and we'll reimburse you on the back end or whatever it happens to be. We're not talking about somebody who inadvertently did this. We're talking about somebody who did it purposefully. And in those cases, there should be a clear hearing before any of the money is returned to them. I mean, the reason that it is supposed to go to the city in the first place, if I understand it in any reasonable fashion, is that there's a penalty for not following the law. And if it's simply a blanket statement where if you break the law, but you correct it before we catch you, you can have your money back, it just is totally against public policy and totally unethical.
Thank you.
Thomas Piccirillo. I would encourage the commissioners, though, to speak into their microphones when they're discussing these recommendations so that the members of the public can actually hear what motions are in front of the public. I would, since the recommendation 2 is directed not to the commission, I would urge the commission just to agree with the recommendation of the grand jury, and that is the city attorney establish an independent audit to see if there was any improper conduct, either by contributors or commissioners or their staffs. Thank you.
All right, I will call the motion. Commissioner Keene?
Yes, rather than... Oh, okay. Can you hear me? All right. Just so it doesn't get lost in the shuffle because we go on to other things and we forget about it, could someone make a note that in our next meeting, we do revisit that August 2008 policy that's being talked about, having to do with this matter of money that's doesn't have to be forfeited to the city if certain things have happened. I would just like to take note of that now, so otherwise I'm going to forget later, and we won't have a discussion on it.
Yeah, can we ask the staff to make a note that it put it on the agenda that we revisit the August 2008 policy to which reference was made? Right. I'm going to call the motion.
Going to vote right now.
Yeah. All those in favor of the amendment to finding and recommendation number 2 in favor? Aye.
Aye.
Opposed? All right. Shows that it was unanimous, and the record should also reflect that the chair has returned and now in charge.
First of all, let me express my sincere apologies to all who are here, to the my fellow commissioners, to the grand jury. I miscalendared this event. It was calendared while I was out of the country dealing with a medical emergency, and I just screwed up the time. So my sincere apologies, and I will certainly get caught up on what occurred, and we'll be here for the rest of the meeting. Let's take a 5-minute break. We are back in session for the special meeting of the Ethics Commission regarding the Civil Grand Jury Report. When we took the break, we were just about to start finding number 3. Any comments from the commissioners or amendments to finding number 3?
Yes, Mr. Chair, this is another one that I just don't understand why we're answering it the way we're answering it, and I would just change it to that we agreed. With the finding number 3, which states a broader citizen's right of action to enforce ethics laws will provide assurance to the public that the laws will be enforced. That's like an apple pie and motherhood type statement in terms of something that's desirable. And what is our answer? We disagree. Why do we disagree with that? That a broader citizen's right of action to enforce ethics laws will provide assurance to the public that the laws will be enforced. Any kind of in my opinion, any kind of broadening of the power to enforce ethical actions in our society is to the good, whether it's by a right of action to citizens or to anyone. So we should just agree with it. And the recommendation that that this can be done by the Board of Supervisors enacting a particular provision that gives a citizen a right of action, like sort of a Private Attorney General's Act, I guess, or something similar to that, to enforce cities' ethics laws with an award of attorney's fees. That's an incentive to citizens to help out in regard to ethical matters. And if the jury has found that that would be good and that the Board of Supervisors should be asked to do that, I think we should join in with them.
Other comments from the commissioners?
There's some legal, wasn't Proposition J struck down by a court? And there's a question whether or not that law is what's controlling?
You're right, and we should take out. We should take out the as was provided by Proposition J, because I think that just sets the thing up for an attack in regard to the Los Angeles court decision of 14 or 15 years ago. But in regard to the general notion itself, I think we should agree with them that as to that finding, that apple pie and motherhood statement in that finding 3, and also agree that the Board of Supervisors should attempt to set up something in accordance with that citizen's right of action. I'm not all that conversant with the particular reasons why J was struck down, whether it was struck down because of it having something like that or other things in it. But I think taking out the language that we're using Prop J as part of the imprimatur of it, I think we ought to agree with it.
I think that what the court held is that the sharing of penalties with the filer may not be legal. I know there are whistleblower statutes and things of that nature that provide those kinds of things, but anyway, I don't. When you say asking the Board of Supervisors to enhance a right of action, is there a general right of action at the present time for somebody unless they can show personal injury?
I have no idea.
Themselves? I mean, that's the problem.
I have no idea, but if the Board of Supervisors were to see fit to take a shot at passing something like this, and then it were to go through the courts again, maybe it would be upheld. I mean, Prop J, as I recall, was struck down by a district court or a lower court in Los Angeles about 15 years ago, but was never really contested beyond that. So I mean, we're not talking about the Prop J decision being one that was done by the U.S. Supreme Court or the California Supreme Court, as I understand it.
May I make a suggestion? I agree with Commissioner Keene that the portion of finding 3 that basically says we should do whatever we can to help better enforce the ethics laws should be agreed with. Now, whether that mechanism is through a citizen's right of action or not, I think is something that needs more analysis and is really something the board needs to do, I think, not the commission. So I think we can agree with the finding to the extent that, you know, we should be doing everything we can to provide assurance to the public that ethics laws will be enforced, but that we need, I think, more analysis and to figure out precisely who is the one who could propose a citizen's right of action for ethics laws and how specifically that should be implemented.
I would propose, consistent with one of the comments. I'm sorry, thank you. I would propose that our response to finding 3 and recommendation 3 is that we agree with the finding and that the Ethics Commission will investigate whether or not it should make a recommendation to the Board of Supervisors that it enhance a citizen's right of action. That would be consistent with the complaint that was being made that we should be more proactive and take on sort of the policy thing. But I agree with the chair that we don't have enough real information about what a private right of action, citizen's private right of action entails, but that we could put it on the agenda as something that we should investigate and determine whether that is would be an effective mechanism.
I think that's fine. I'd accept that.
Sure.
Any other comments on finding 3 or recommendation 3?
So that language then that about disagree and also the language at the top of page 3, that should go out.
I think for the recommendation 3, we would say that per the vice chair that, you know, we need to look at whether enhancing the citizen's right of action would be the proper mechanism for enhancing enforcement of ethics laws, so that if so, we could make a recommendation to the board.
I think specifically, though, Mr. Chair, we have to take out that proposed language, or, for example, at the top of page 3, absent a problem with the status quo and other types of things will not be implemented. That no longer has any application in regard to what we've done.
I think the whole recommendation would have to change.
Okay.
Yeah, my motion was not to, under recommendation 3, is that the commission will investigate to determine whether or not an enhancement of a citizen's private right of action would accomplish the further assurance of the public that the laws will be enforced.
What did the city attorney want to say something?
Yeah, the deputy director. The deputy director just wanted me to clarify or confirm for the commission's benefit that there is currently a private right of action provided in the Campaign and Governmental Conduct Code. But it doesn't necessarily provide as broad of a remedy as previously provided by Proposition J. So currently, any resident can file for injunctive relief for any violation or alleged violation of the governmental ethics ordinance. It does have to provide the city attorney of notice of intent to file such a suit, and there's not necessarily a guarantee of attorney's fees.
Okay, so if we have enhancement in there, then that
exactly
covers us.
I think that's fair.
Okay. Okay, so then as a procedural matter, with the motion out there, we're taking public comment, and then and then going to the vote. Okay. Is there a second to the Vice Chair's motion?
Second.
Public comment.
I'm Bob Planthold. I'm glad you're taking this clarifying action. And I also wanted to point out, in the various notices to interested parties and the various workshops that Ethics has had over the years, I've never seen any indication that the public is notified they have a private right of action. It might be worth putting that in boldface or somewhere so that the public feels maybe Willie Brown can do his own right of action, or Danielle Steele, people with their own resources. They don't need to go through you folks. I think it would help if the public knew that, because I was not clear that we could bypass ethics or FPPC and go straight to court. That's something, again, that could benefit the public to know. Thank you.
Just to clarify, the reference to Prop J here was really sort of about the procedure that was in Prop J that required notice to the city attorney and a waiting period before a case could be brought. And yes, the law now provides for a private right of action for injunctive relief only. There's no mention of attorney's fees. So this, is discussing a broader right of action. As Prop J is going to come up again later, I do want to say it's a little, the judicial history on Prop J is a bit convoluted, and in fact, some cities did implement it in one form or another. There were issues raised about First Amendment rights and things like that, but it's sort of piecemeal decision that really didn't decide everything one way or another, but we allude more to concepts that were in it than its actual content.
Larry Bush from the Civil Grand Jury. Also, we point out that the FPPC and the City of Los Angeles both have a private right of action with attorney's fees. And so partly we drew on that when we drafted this. In terms of Prop J, the reference also is the fact that that was approved by the voters by over 80% of the vote. It was overwhelmingly positive. When there was a rewrite of some of the provisions in 2003, there was no mention of the fact that that rewrite eliminated the private right of action.
As a people's advocate, I have experienced many have a lot of experiences trying this citizen's right of this or that. And some 20 or 30 years ago, I remember having an opportunity to question heads of departments before the Board of Supervisors as to how their conduct of their departments. And it was certainly a good experience that the citizens had a right to question, not just department heads or supervisors, but when the heads of the departments were defending their budgets, that the citizens could ask. I had a recent experience, fairly recent in the last year, of trying out the process of complaints or to correct something wrong in the Senior Citizen Center. There's on the walls there are forms which you can make a complaint to an unidentified person or body about things going wrong. I've had a acting head of the senior center on 8th Street, about the 100 or 200 block, but I wanted to know who this goes to, because it can be somebody defending the person that is complained about. The person was acting head, and when I would come into the dining room, would insist that I sit down at a table. I'd like to look and see what his being served me, or say, I do not want any of this. Do you have a substitute for pork or whatever it is? And the chef would find that a reasonable request. But I was told when I insisted on looking at what was proposed to be served me, and it doesn't always follow any menu, that I have to sit down. And it's just get away from what we want to do. And given a 30-day DOS, denial of service, that I couldn't have lunch there because I didn't always sit down instead of looking and seeing and doing a reasonable thing. And I found that when I tried to make a complaint find out what office it goes, the county agency, that I got a very defensive reaction. What's it about? Who do you talk to? I'll talk to them first, and then I'll get back to you.
Thank you, ma'am.
What kind of a process do you ever want to do that again?
Thank you, ma'am. Appreciate it.
Commissioners, Ray Hartz, Director, San Francisco Open Government. I wholly agree with the change that has been recommended. I think the language here really, there's never been an apparent problem with the provision of a citizen's right to action in current law. I can point to my own case regarding the city librarian. He used his office for 2 solid years to withhold public records that he had an obligation to disclose both under the Sunshine Ordinance and the California Public Records Act, because he didn't want to disclose that he was getting $5,000 a year approximately from the Friends, and then filing statements of economic interest each year under penalty of perjury saying he got nothing. And it took us 2 additional years to take that to the FPPC because he used his position to deny us access to those records, which is in effect denying our access to the law. I mean, we would have been limited to going to court because we didn't have the records, as we were limited by going to the FPPC. And we're also talking about an equal protection issue here. It's all well and good to talk about a Danielle Steele or some important person who has millions of dollars that if they particularly decide they want to correct something that's unethical in from their point of view. But what about the average citizen who doesn't have that ability, who only has the ability to go to the Sunshine Ordinance Task Force or to this commission and ask for that assistance? You know, where is their option? And so, yes, I agree with the recommendation. Basically, the ethics law should be something that if you won't enforce it, the individual citizen can. Whether or not they get paid, I didn't get paid, and the other people involved taking the city librarian to the FPPC didn't get paid anything. And we put in a lot of extra effort and time and energy, including going to the Sunshine Ordinance Task Force 5 times to get some of the records, going to the city attorney's office twice with petitions, both of which were denied, even though he ultimately admitted that he withheld the records. So it's really kind of bizarre that it says here, even imagining, to our knowledge, no one has ever attempted to use or even inquired about this right. That's what I've been doing here for the last 2 years, is saying, wait a minute, I'm entitled to these records, and the city librarian is using his position as city librarian to withhold them because he doesn't want to expose himself to having lied under oath. And yet each and every time this commission voted to find him to have not violated it, even though he had been found to have violated it very clearly by the task force on 5 separate occasions. You have to give the citizens the right to do something if you're not willing to do it, and you certainly can't stand in their way.
Welcome, Chairman Herr.
Thank you.
I would prefer to see the recommendation as is by the grand jury report. I don't like the modified language that you're proposing about studying to see if there should be a stronger citizens' right to enforce the existing ethics laws in the city and county of San Francisco. I think you are going to strike the proposed recommendation. But the statement absent a problem with the status quo, I believe the substance of this civil grand jury report is that there is a problem with the status quo. So I would urge you to adopt the language of the grand jury report regarding finding 3 and not pass the proposed motion being discussed. Thank you.
The motion pending is to modify the finding number 3 and recommendation number 3. All in favor?
Aye.
Aye. Opposed? Hearing none, that motion passes. Move on to finding 4. Any comments from the commissioners on finding 4 or recommendation 4? Commissioner Keene.
Yes, Mr. Chair, just one, and it's a minor one as to language, but I think it's important in regard to the whole tenor of the response. It has to do with the second full paragraph from the end of the page, where we have the language, the director also notes that the commission has already made progress in moving its many filings into electronic databases. Just with all due respect to Mr. St. Croix, I think this is the response of the commission to the grand jury. So I would strike that language that the director also notes that and instead just put the commission notes that there has already been made great progress in moving, etc.
That's a worthwhile change. May I also propose that we do 4 and 5 together, because they both relate to the searching of electronic data?
Okay. And I have the same response in regard to some of the language in 5, where we say recommendation 5 in our response, the third full paragraph from the bottom. At the end, you have the same problem where it says the commission and the director note that the campaign, etc. I would strike the words "and the director note," just the commission notes, because this is a response of the commission, not the response of the executive director. Again, with all respect to Mr. St. Croix. The other thing that in order to have a more civil tone to our response, going along with what I had said at the beginning, is up under paragraph 3 on page 4, where we say disagree partially, and we say this assertion is not completely true. I would ask that we use the term not completely accurate. To say something is not true, there's sort of an implication that the grand jury is being false here, and I think that would be unfortunate of us to do. So I would ask that change also be made. Those would be my observations as to number 4 and 5.
Thank you, Commissioner Keene. Any other comments on 4 or 5 from the commissioners? I have a question about both of these. And I confess it may be a deficit in my technological capabilities, but I do find it surprising that we can't make these forms searchable, especially if they're filled out electronically. And I'm not quite sure I follow the argument that we don't want to do it because there may be state regulations later on that would possibly affect how they're searched. So maybe some further help would be appreciated.
Stephen Massey, Information Technology Officer. So the Form 700 is the form that we reference here, and the state has recently passed regulations that allow us to do electronic filing. So that's why this has been the first year that we've done it. And part of the regulations didn't address the actual format of the information. And I think that there is a benefit to having our data be in the same format as the same electronically filed data in other cities and jurisdictions. So if we go ahead and we build a database based on our own specification, and then it doesn't end up matching the state specifications that come out later, then we'd have to go through and change how we're collecting this information. The state, we know, is already working on specifications, so it's, I think, in our best interest to wait until they finished that process and then build a searchable database.
So right now, what is the format of the Form 700 data?
So there's two formats. There are two proprietary formats right now. There's a format that's controlled by NetFile, which is the company that we use to collect this information. There's also a format that's controlled by SouthTech, which is another company that collects this information in other jurisdictions. So what I was alluding to is that it would be in the best interest of us to wait until the state has created that specifications, so that SouthTech and NetFile will adopt the same schema. And then all the data, regardless of which vendor collects the information, will be reported in the same manner.
How much do we think it's going to cost to make the data searchable?
We haven't done an estimate. I don't think it will be very expensive because every city that is using NetFile's system or SouthTech system is going to be interested in having this functionality. So generally, features that are added to the system that are shared by many different jurisdictions are not very expensive to develop. It's features that are unique to San Francisco that are very expensive to develop.
And when do we think there is going to be a common schema statewide?
We were told that possibly by the end of the year that they would develop a schema, and then from there we could proceed.
Okay. Perhaps we could add to this recommendation then that we'll revisit it at the beginning of 2015, because what I don't want is for this to slip. I think it's really important. I think the ability of the public to search and cross-reference these forms really is a critical component. And Mr. Massey, you've done a great job, I think, with a lot of our data. And the more we can do about this, the more transparency we can provide, I think the better. Any other questions or comments for staff? Public comment on 4 and 5?
I'm going to talk about Form 700 and its failure to address some serious problems in the city or make problems worse. The city has participates in the state tax law against tobacco and has good, I'll put in parenthesis or quotation mark, good uses for the money it gets from the sale of tobacco products. The people in the homeless shelters have been used as victims for the city's desire to get more and more money for the First 5 program, namely the program for pregnant women and children up to 5 years old. They get about 87, the state gets maybe about 2 cents, and the city and the county gets about $1. It gets maybe about 75 cents per cigarette package. According to the health people in Atlanta that do a lot of statistics work, the cost and social costs of shortened life expectancy and welfare costs like county hospitals from cigarette smoking is very high, about 7 times as much as the county gets of San Francisco, city and county, from the sale of a package. the chair of the local homeless coordinating committee in San Francisco, which on the face of it requires that people, unless there's a real strong excuse, who are on the commission to live and be or be employed, I think, in San Francisco. But for about 2 4-year terms, through the state, through the county controller, this position has gone to a person who lives in Berkeley and is employed by the Children's Hospital in Oakland, and is head of one of numerous grants to the Children's Hospital there for primary care of the patients, and it's highly funded to her employer. And she's been on the local homeless coordinating committee in San Francisco, and the health department in San Francisco is...
Thank you, ma'am. Appreciate it. Your time is up.
I'll just finish a couple of sentences.
Ma'am, there's a lot of people who want to talk on this issue, and there are going to be many opportunities for public comment, so I'm going to hold everybody to the 3-minute limit.
But I want to say she was appointed to defend the source
I'm very sorry to do this to you.
In the shelters.
But we're going to turn off the mic right now.
Cigarettes.
Ma'am.
Promoting cigarettes at the expense of the people by misappointments.
Thank you, ma'am.
Commissioners, Ray Hartz, Director, San Francisco Open Government, and I support the change to the recommendation or the response to the grand jury. I also commend Commissioner Herr of putting a deadline and saying a specific date as the beginning of 2015. The Sunshine Ordinance included a provision where it mandated that as new electronic and computer systems were implemented, one of the things that had to be included by all departments in the city was an ability for citizens to access public records. And I have argued this for a number of bodies from a simple statement addressing one issue you have repeatedly raised in your response, which is economics. If I could go online and get a lot of these documents, which are not confidential, but are matters of public record myself, it would save the staff immense amounts of time and energy responding to public records requests, which they invariably complain takes up an immense amount of their time. If I could print them at home, it would save the city a whole bunch of paper providing me those copies. There are just all sorts of advantages of having these things, and since the law, the Sunshine Ordinance has said for over 12 years that this should be the case, having them searchable is also appropriate, because that way the search and the utilization of the computers involved in the system are minimized, and the benefit of using them is maximized. So basically, all of these things are things that should have been done long, long ago. Putting a recommendation in saying basically, well, let's look at this by a date specific is, I think, very critical, because otherwise it will tend to just slip away. And the bottom line is the citizens of the city depend on access to public records. And I'm going to belabor this point because I've dealt with it so much. You have city departments and city officials, elected officials and appointed officials, including department heads, who will use their positions to withhold public records from the public because it discloses their own poor or bad behavior. In some cases, like the city librarian, illegal behavior. He perjured himself for 3 years. He delayed giving us the records for 2 additional years, and during those 2 additional years, he perjured himself 2 more times, saying he got nothing, and then he had to come back and admit what he'd done. If those records had been online on the library or the Library Commission's website, it would have been easier to get it, and the action would have been more timely. So it's also a matter of due process and a matter of equal access. So I think it's very appropriate that this be looked at and be implemented and a date certain be included.
Welcome, Commissioner Hurd.
Thank you.
I appreciate the discussion on this topic, and I appreciate the way you want to reframe the response to the finding and recommendations. I think the points raised by Mr. Massey were helpful in understanding what's going on with the state data scheme on the Form 700, and I think it's worth including in your response just to give a little more flavor to what's going on. Thank you.
Although I appreciate the patience exemplified by the chair, I'd like to see that public comment be directed toward the motions in front of the commission, so that you can go finish the recommendations of the grand jury. And it's not clear to me what, if any motion is being made on 4 and 5. So perhaps the clerk could summarize. Is there a motion on
the motion was not made, but the motion that is intended is to modify responses 4 and 5 as proposed by Commissioner Keene, and to add a date certain, beginning of 2015, for the commission to revisit the issue in light of Mr. Massey's comments.
Okay, so then my additional public comment would be that all the language used by your staff be stricken, and then you can enact or not enact a motion regarding 4 and 5. Thank you.
Thank you.
Welcome, Commissioner.
Thank you.
Charles Head, Civil Grand Jury. In the introduction to the Civil Grand Jury report, state law requirement has to do with, as to each recommendation, the responding party must report that. Then number 3, the recommendation requires further analysis. The officer or agency head must define what additional study is needed. That goes into the technological progress coming down the line. But specifically, the grand jury expects a progress report within 6 months. So I would recommend that you mention that time frame and say specifically that particular time frame, 6 months, rather than, well, we'll revisit this in 2015, probably at the start of the year. That's, to me, a little too vague. And also, I would call your attention to the last item, last line on page 3. This recommendation includes behested payment forms which are not filed with the Ethics Commission. I think the grand jury intended that behested payment forms should be filed along with all these other forms. The behested payment forms are important, just as Form 700 is. Thank you.
Is there a motion to adopt the changes to findings and recommendations 4 and 5 as proposed by Commissioner Keene, and to add that the Ethics Commission will revisit both issues by February 2015 to address the issues raised by Mr. Massey?
So moved. Second.
All in favor?
Aye.
Aye. Opposed? Motion passes unanimously. Any comments or changes to the findings and recommendations in number 6? Any changes to the findings or recommendations in 7? Oh, Commissioner Keene.
Yeah, as to 7, Mr. Chair, I would propose that, for one, where it is, the grand jury is asking us that we provide written information, as does every other city department, in all of the other major languages, which is also done by every other city department. And in the proposed, the draft proposal is that we disagree and will not do this, saying that it is an unwanted service, and it has been determined that the demand for such services is 0%. I find this hard to believe. In a city as diverse as San Francisco, with all of the languages and all of the cultures, where every other city department, as we're told here, provides this information in those languages, yet somehow we are saying that in terms of what we're doing, either what we're doing is so insignificant or unnecessary, or people who speak only other languages don't care about it, that we should not provide this information in those languages. So I would change our recommendation that that the Ethics Commission shall make the guides and education materials available in the major languages, as is done in other city departments.
Other comments from the commissioners? I did have some questions as well on recommendation 7, in particular what the formula is that led to the conclusion that the demand is 0.
There's 3 different approaches that each agency can use that the city requires. Looking back on whether there have been any requests for bilingual services via phone or in person in a prior calendar year is one of them, and I'm sorry I'm not able to recall the other 2. But in the case of the past several years, we've done the different 3 analyses, and we haven't had requests for translation of documents, translation of phone calls, or any in-person requests. We do have staff. Currently, I think we have 7 languages represented on the staff if people need live bilingual or interpretive services. But in terms of the demand, it has not yet existed.
And what is the cost for making these guides available in the major languages represented in San Francisco?
I don't know. It will be expensive.
Yes.
I'm sorry,
Commissioner Andrews.
Mr. St. Croix, you said it will be expensive?
I think so. We're a Tier 2 department, so I think there's 4 languages that we would address if we were to set out to do this.
Commissioner Andrews?
Yeah, I mean, this one is a little, I'm troubled with this one as well. I'm reminded of this quote, better to have and not need than to need and not have. And I'm not sure that just because a need hasn't been identified that it still is not the right thing to do, particularly since other city departments have them, whether people take advantage of them or not. So I don't know that I have much more to say other than that, but I certainly don't fully agree with the last bit of that statement that says it would not be a good use of financial. I think it would be a good use of financial resources if indeed we had them. And I'm not exactly sure that it's an unwanted service.
I might propose that we maybe do a little case study here. I'd like to know what it would cost to make some of the guides, particularly those that involve donations to campaigns, that kind of thing, where it seems more likely that someone who doesn't speak English may be politically involved. And so I'd leave it to the staff to try to figure out a few examples and to price those out, and let's see what it would cost. Because I'm also a little concerned that maybe these people are just not calling you and asking you, but that there may be a need. And if we did it on a trial basis, then we could really tell. If nobody ever picked anything up that was in a foreign language, then that would be also useful information. So I guess I would propose that we change the recommendation to say that we'll analyze whether the cost and pick out specific guides that we think would most affect the public and see what it would cost to make those particular guides available. Any reaction to that from the commissioners?
I'd oppose that. In regard to the item itself, the fact that we are in San Francisco, we're in such a diverse place. We recognize and honor that diversity, and we, in almost everything that we do, we accommodate people of the different languages and culture. That, to my mind, it's a no-brainer that this department should do it just as much as every other department does it. And I don't think we need any kind of study. I think we should just do it. And I would move that we do it.
My concern with that, Commissioner Keene, is that like any department, we have limited resources. So spending money here means not spending money somewhere else. And so, in my view, in order to determine what the most efficient use of our resources is, let's not spend on a great deal on something, one, that we don't even know the cost of, and we don't think there's a demand for based on at least the city formulas, and test it out before we commit resources there and therefore limit our ability to commit resources elsewhere.
No, I understand what you said, Mr. Chair. I disagree with you.
Okay. Is there a motion to amend finding 7 and recommendation 7?
So I move that we amend recommendation 7 and that that the Ethics Commission should make the guides and educational material available in the major languages as is done in the other city departments.
Is there a second?
Second.
Public comment.
Commissioners, Ray Hartz, Director, San Francisco Open Government. The old expression, the longest journey begins with a single step. The bottom line is, if you put the recommendation that was recommended by staff out there, you're basically saying we're not going to do this at any time, because that's really where it's at. And I agree with Commissioners Keene and Andrews, and including Commissioner Herr, is that I don't, it isn't like we have to take every single document and translate it into all the languages, but take the major ones that most people are going to be interested in. In other words, if someone is running for the city office, they should have some idea in their own language as to what is required for them to file appropriately for the election, to file whatever financial documents, what campaign workers or people like a treasurer or so forth are required. I mean, if they don't have that basically in their own language, then they always will have the defense that I did this because you didn't provide it in any language that I could really understand. And not only did we have the problem with the legal definitions, we had problems with the language definitions. And so you have to start somewhere. And I think that the motion as amended would at least start the ball rolling. And if it is found out that nobody is interested in it, then you don't have to go much further with it. But I have a serious doubt that in this culture, if we really want to show that we appreciate the diversity of this city, then we have to be proactive, not passive.
Richard Nee. Just a suggestion, either identify what those major languages are or set up criteria for identifying what those major languages are. Populations can be fluid, so what the major languages are today might not be that in 10 years.
Yes, very quickly. I'm a strong supporter of the motion by Commissioner Keene. It is a no-brainer. In terms of cost, all of the city departments have guides, materials in Spanish and Asian languages, Mandarin, Tagalog. So this should be a priority. And if your resources are limited, then cut them someplace else. But you don't need a study to see if there's a need for materials in other languages. Perhaps 40% of the electorate in the city now is not English speaking, right? So it is a no-brainer, and I support the motion by Member Keene. Thank you.
Hello, Commissioners. Joe Kelly. I am a member of the Civil Grand Jury as well. I wanted to just suggest that I don't believe Commissioner Keene referenced every department doing this in all languages with, I got the sense, all the documentation. I don't know that it's every department doing it. And with all the documentation that's being put out there. So I would just suggest that Commissioner Herr's suggestion of studying it is worthwhile in, piecemealing it out there and seeing what kind of response is taken on the information.
All in favor of Commissioner Keene's motion? And just before we get to it, what are the four major languages?
There's three.
There's three?
Spanish, Mandarin, and Tagalog.
And Commissioner Keene, is that what you would propose? Everything be, all the educational materials be made available in those languages?
Yes, I think Commissioner Andrews has.
Commissioner Andrews.
Mr. Chair, I was just wondering, and then we're talking about resources now, if and I totally get how we are creating a bit of an unfunded mandate. Is there an opportunity to go to the city to find some resources that we can do this? Could we go to the mayor's office and at least the staff and say that the commission has identified a particular need, or the civil grand jury identified a need and the commission agrees with it, and we would like to move forward with these three languages? Is there a cultural competency office in the mayor's office, or at least use one of the Department of Public Health, who I know has a large cultural competency department, be able to use their resources? Just thinking of kind of creative ways in order to.
If another department agreed to do it, we would have to pay them. So if there's a large cost to this, we'd have to go to the mayor's office, request a supplemental appropriation, which would have to go through the board.
Any further comments from the commissioners? All in favor of Commissioner Keene's motion?
Aye.
Aye.
Opposed? I oppose. On the grounds that I'm concerned about the budget. Okay, finding number 8. Any comments or questions relating to the finding and recommendation 8? Okay, finding number 9.
Hello, I'm Larry Bush from the Civil Grand Jury. I would just like to point out that while many of these recommendations suggest that matters be referred to the Board of Supervisors, it's worth recalling that the Ethics Commission has the authority to put measures on the ballot itself, with 4 members of the board of the commission voting to put something on the ballot. And up until about 2006, that was done a number of times. It has not been done in recent years. But if the issue is going to be additional public disclosure of how money is being spent to influence the public towards a certain decision, it seems like it would be a pretty easy pass for the voters, but not such an easy pass for the Board of Supervisors. So I would just have you recall that this commission is one of the very few that has the authority to put something on the ballot itself, and has done so. And each time it has done so, it has prevailed with the voters.
Were there any comments from the commissioners on 9? Comments on finding and recommendation 10? I just wanted a little more clarification on recommendation 10. Can, Mr. St. Croix, can you explain that recommendation response a little bit further?
Well, we're not entirely sure exactly who the strategic advisors are that are pointed out, but it would seem that if there are professional people that are advising groups or companies or whatever on ways to influence public opinion, that would likely be beyond the scope of what we could regulate.
Why?
This is Jesse Minardi, Deputy Executive Director. Again, we're trying to determine exactly what strategic advisors mean, but to the extent it means somebody who might have a knowledge of the workings of City Hall or government and then are advising people without themselves making a direct contact and thus triggering the lobbying ordinance, it would be contrary to pretty much every regulatory regime lobbying related that I know, where you would require reporting and registration for that person just by virtue of advising for compensation how somebody might go about influencing City Hall. Usually has to be the contact, which is what we see in the lobbying ordinance.
I see.
So to the extent that's what the issue is, that's what guided, my understanding of what guided this response. So.
Okay.
For us in the grand jury, this is one of those gray areas where it's really not clear whether this person should be registered as a lobbyist or whether they're sort of at the front end of a campaign that's going to be on a ballot question. And it's one of these areas that should be evaluated as part of thinking about how effective the laws are and whether they really work. Not necessarily to say to a person, oh, what you're doing, is really lobbying, but just to kind of point out to the public what the full range of what's going on here is. Because public relations is a whole industry that's really grown in the last 20 years. That's often seen as separate from lobbying and separate from campaigning, but it all ties together in the real world. And I think people deserve a better picture of what's going on in that regard. Thank you.
So who specifically, or what type of individual did you have in mind when the
I suggest there's a number of former public
advisors?
officials that hold themselves out as strategic advisors to corporate clients.
Okay.
Question, would
Commissioner Han.
Would this include like permit expediters at the planning department, or are they already included?
They're already included in the new lobbyist rules.
Yeah, that was I had relatedly was wondering if that's what they were, what you all were going after. Mr. Head?
Thank you, Commissioner. As I recall, there have been so many cases since this jury's been in session of a person who is not necessarily a former city official or anything like that, but just basically is acting to influence public opinion. And then when he's called on this and said, well, you've accepted more than X number of dollars, therefore you have to register as a lobbyist. He says, I'm not a lobbyist. I'm just a director of public information, or I'm a public relations person, or I'm a strategic analyst. I'm not a lobbyist. And this is something that we've encountered a lot in the course of our study, and that's why it's in our study. Thank you.
Mr. Minardi, did you have something?
Jesse Minardi, Deputy Executive Director. It's certainly an issue, particularly at the federal level. You see this issue of folks who are evidently, familiar with the workings of government, advising clients with regard to same, but they do not, for whatever reason, trigger the lobbying law. And as a result, that compensation isn't captured. With the lobbying ordinance change recently, I think there was a deliberate attempt to cast the net as wide as possible. So now if you're an outside lobbyist, as you will likely recall, and you make one compensated contact with a city official, you automatically have to register at that point. So there's the lobbying sort of regime. Then there is this issue of what's commonly known as grassroots lobbying, or information directed towards the public saying, hey, please contact your public official to tell them to do X, Y, and Z. And that actually gets to some of the expenditure lobbyist issue, which is, I guess, addressed a little bit earlier. And it is true we do not have a regime for that right now. So the question is whether that's called for or not, and obviously the grand jury thinks to some extent that it is. So hopefully that makes sense.
Any other comments from the commissioners on finding recommendation 10? Finding and recommendation 11? I also wanted some clarification on 11. I don't know if it's the city attorney that should talk about the upcoming case, but I'd like to know what the posture is and why we think it's maybe going to change this.
Sure, Deputy City Attorney Andrew Shen. So I believe what the staff is proposing in terms of recommendation number 11 and the reference to an upcoming Supreme Court ruling is a reference to an upcoming California Supreme Court case involving the city of San Jose and whether emails sent concerning city business on the officials' private email accounts are subject to the Public Records Act. That's an important case that we're obviously monitoring internally, but I believe that's what was referred to in the response to recommendation number 11.
Okay.
So that should shed some light on this area.
Okay. And so we think that if, I guess depending on what the California Supreme Court decides, this could extend to other electronic communications other than email.
Yeah, and that case even isn't so much about email. It's just to the extent an official could use private lines of communication, email, text, otherwise, and sort of claim because it's not on the city or public email system or communication system is just automatically not subject to the Public Records Act, which was what was essentially argued by the city of San Jose. Sort of that question, which the city attorney's office has actually frankly sort of consistently advised, public officials shouldn't make that argument. But it's definitely a gray area, and it's definitely an area where the law is developing. Mm-hmm. And I think that's all the commission is trying to get at in this response, that things will become clarified as time goes on, especially with respect to these new communication technologies.
Has an oral argument been set for this, or has it already been argued?
I don't believe it's been argued yet.
Okay.
Yeah, no, I don't think so. Yeah.
This is another one where I would like to revisit once we know. So if you all could keep us advised of when it's argued, and of course when it's decided. Any other comments from the commissions or proposed amendments to 11? I just wanted to check in with the commissioners and the staff and perhaps the public as well. We are now almost at 1 o'clock. We are not halfway through, I believe, the recommendations.
29 of them.
Yeah. Do we want to take a lunch break?
Yes. Let me address this to the chair. As I had understood that I think we have this room until 3 or something. I had made a commitment for another legal matter that requires me to be at 3 o'clock, so that I would ask to be excused from the afternoon session.
Any, that's certainly fine with me. I don't know if any other commissioner has a comment or thought. Okay. Okay, so should we take 45 minutes? Okay, let's plan to come back at 1:40. Until then, we'll be adjourned.
One of the primary causes of pedestrian deaths last year was motorists failing to yield to pedestrians. We all need to work together to make our streets safer. So slow down. Give safety a second look. Look twice before entering an intersection.
BONNIEBANKS. Bonnie Banks. My definition of noise is uncontrolled music without format. It's a pretty simple affair. Pancakes and then ear blast Well, people get up Sundays usually around noon, the weekends or whatever, so it shouldn't be too hard to just walk into a place, have your audio alarm clock go off for 2 hours, waking you up while you're eating breakfast with maybe some interesting visuals once in a while. It's improvisation, listening or not to the person you're playing up against, or people, or machine. Try and get as many different people in as possible of different genres of experimental noise, power electronics, dissonance, some drone, very little, tiny bit of ambient. I think the first noise pancake show was 1999. The first God Waffle Noise pancake show was 2001, maybe. God Waffle Noise pancakes started from Noise Pancakes, which came out of Pubis Noir, a place on Mission Street where Brutalo from the Church Police would open up his house just to have Saturday morning cartoons in 3D. But a big space, you can have everybody set up the whole show and barely even move their equipment around, which is great. It's more room for an audience to move around and walk over and get pancakes without getting burned up in the kitchen. There's like people into hardcore gabber, there's people into punk rock, there's people into like really fast death metal, black metal. There's, you know, people who don't listen to music at all. A guy like Larney Fox set up this huge motor-driven harp. I don't know how to explain it. There's maybe 40 little motors that he had running over strings and wires, and then played each string individually with a mixer. There is a feeling of euphoria when somebody is really good at what they do. If you're at a live show and you're experiencing a subwoofer trying to push your bowels out of your rear, it's a lot different. A lot of noise acts, you gotta realize, don't get to play clubs that have a cleaning schedule, a guy coming in the morning and emptying the beer bottles. They'll play a warehouse or a bedroom. If you've traveled around, you'll see the exact same kind of weirdos doing their own thing. It seems like in the Bay Area, it's even more absurd. There seems to be a lot more people than in a place like New York or Tokyo. We did a show in New York, and people that I didn't think anybody was at hardly have come up and said, I saw this show. I wish there was some kind of breakfast noise thing going on out there. I think a lot of people have just like beamed walking out of those shows, or just said that was incredible, or I can't believe it's over already, you know, after 2 hours. If you're reluctant to enjoy something like this, it'll probably take a mass of peers to sell you on it, so it's fine if you stay away. It's most of the people that come to these shows are pretty happy to be there. You may not be one of them, which is fine.
The importance of computer literacy is at an all-time high. With many services moving towards internet access, it's important we stay in the loop. The Department of Aging and Adult Services aims to help close the digital divide that exists between seniors and the rest of the community. Our senior centers offer free internet access and training, making it easier than ever to get connected. For more information, visit sfconnected.org.
Please give it up for our Teachers of the Year. We're really excited about the leadership that we have in San Francisco. There is no doubt that he is serious about public education and certainly taking great care of our youth. Please join me in welcoming Mayor Lee.
Thank you, Haija. This pick is part of an overall appreciation for the best school district in the country, San Francisco. There's no longer a competition between us and Oakland or us and San Jose. It's about us and the whole world and how we're going to utilize our innovation center to produce the best educated kids and the most compassionate kids, the kids that will learn about life as well as arts, as well as science and technology.
And I know that if we were to ask every one of you, you would say, well, thank you, but I'm really just representing many more of my colleagues in the district. We know that's how you feel, but I'm going to ask a favor of you today. Just take it in. Just take it in today, because this is really about all of you today.
Our first award recipient is Miss Marissa Miller. She's our pre-K special education teacher from Paul Revere Elementary School.
My teaching style is definitely implementing an interdisciplinary model. We embrace family partnerships, and everything we do is child-centered and child-driven. The best part about working with my students is the second I get there until the second I leave, I am often the person who hears their first word or sees even their first smile. And I feel that they give more to me than I could ever give to them.
Marissa, congratulations. Our next award recipient is Judy Vertal from Marshall Elementary, first grade Spanish Immersion.
I enjoy this kind of work. There's so many surprising things that happen every day. I've always taught either first or second grade. There's something about children at that age when they're just on the cusp of learning to read and they're just starting to learn how to be students that is really interesting to me. They're learning how to formulate questions and to understand the world around them. To be a successful teacher, you have to continuously learn yourself. You're not done when you graduate from college, and you're not done when you get your teaching credential. There are always new types of teaching strategies to learn, but also new things to learn about the world itself. And so you have to be a lifelong learner to be a good teacher.
Judy, thank you and congratulations. Kelly Clark, 5th grade, Harvey Milk, Civil Rights Academy.
I got into teaching by being a community member and realizing where the needs were, and I also wanted to spend my life doing something that would help other people. When you take a child bowling, there's the little rails that come up, and that's sort of my philosophy, where you want them to have a free roll, but you also want to give some guidance there and some barriers to make sure that the ball goes down the lane and hits those pins. My teaching philosophy is non-punitive, lots of patience, and pushing kids just towards their better selves.
Congratulations, Kelly. Our next award recipient is Gianna Chavera, 7th grade Spanish Language Arts and Social Studies, Buena Vista Horace Mann KA.
I like to think of myself as somebody who gives a lot of tough love to students. I try to hold all my students accountable to reaching higher and higher standards and developing them as much academic progress and thinking of themselves as scholars as possible, but I am always have them in my heart and really want to offer them as much love and support as I can. And in terms of academic style, I want them to be independent. I want them to seek knowledge out for themselves. I want to be there to help them. I want to provide them with tools so that they can go and analyze and investigate on their own and feel successful. I think the key to being a successful teacher is having a lot of patience and a lot of persistence.
Congratulations, Gianna. And last but not least, our high school Teacher of the Year, Michael Ferraro.
I get them in a certain state, and by the time I'm done teaching them that year, I get to see the immediate growth. It's very gratifying, but then I get to follow a lot of them through the rest of high school and then into college and some of them beyond. And really proud of what they've done, and knowing that I've been a part of that's been very important to me. I think what makes a successful teacher is one that truly cares about outcomes for students, helping them overcome difficulties in their lives and being able to set them on a path that they might not otherwise have been on.
Mike, congratulations. Congratulations, and thank you all, family and community, for coming out.
We are very happy here in the heart of the Sunnydale community to show off this incredible learning that's happening for the youngest San Franciscans in our community. And I think if you have a chance to look at what's happening here, you're going to see hands-on exploration. You're going to see literacy-rich environments. You're going to see math-rich environments. You're going to see language, multiple languages that are spoken and valued and actually celebrated. You're going to see a multitude of cultures and heritages that are celebrated as well right here at this Early Learning Center. So we're extremely proud to start our first day of school here, celebrating with our earliest learners. And we know that the earliest education for children is the most critical. We know that students that don't have the benefit of an early education enter kindergarten anywhere from 2 to 4 years behind their peers who have the opportunity to have rich environments either at home or in other environments, learning environments as well. So it's really not a matter in San Francisco of wondering if we're going to have the expense of early education. We never view it that way. We look at it as an investment in our children, an investment in our community, and we are so proud that San Franciscans have continuously voted to support initiatives that fund early education in our community. We will have that opportunity again in the not so distant future to do that again and recommit to early education for all of our children. As a superintendent of the San Francisco Unified School District, I am also extremely proud to have a school board that is focused on equity in our policies, in what we do, and how we serve our communities. Our equity lens is resolute. And what that means for us is that this year you will hear us speak and you will see us do many things around closing the achievement gap in very tangible ways. In the very near future, we will have on board a special assistant to the superintendent that will focus on African American student learning in San Francisco. And you may ask why. Well, the reason is that we are in danger of losing our African American population in San Francisco. And we know that a city as vibrant and diverse as San Francisco cannot be the world-class city that we are if we don't celebrate, we don't have all of our students in all of our communities achieving at their greatest potential. So we are going to be very unabashed this year about how we are going to double down on our services, our supports, and our inclusion of all of our students in every one of our school communities this year. And what gives me great hope and great solace is that not only do we have a school board that is equally as focused on this task, we also have a city government that is equally focused, and we have a faith-based community that is equally
as focused. So with that, I would also like to welcome here with us today, and everyone will get an opportunity to introduce themselves, but I'd like to introduce a member of the faith-based organizations, and he is actually the president of the NAACP. He is a partner with us, and he stands shoulder to shoulder with us, the Reverend Dr. Amos Brown.
Thank you very much, Mr. Superintendent, for your very substantive and kind words regarding our partnership that we are inaugurating today with our mayor standing here with us indicates that in San Francisco we know how to do the right thing when it comes to making education everyone's business. As we earlier walked through the classrooms and saw the children engaged in early learning experiences, given that I'm a Baptist preacher, I immediately went back in my mind's eye and recalled that the prophet of Nazareth told the story of a man who plowed up a field to plant some wheat. He did a great job of beginning the task. But when he slept, somebody sowed some tares in the wheat. When we walked through those doors, we saw good wheat being planted in this early childhood education experience. And the research and the facts reveal that children basically in early childhood education experiences and in elementary school are all on par with each other in terms of achievement. However, as they move to middle and high school, somebody sows some tares in the wheat. Tares of savage inequality, to use the words of Koziel. Tares of parental neglect. Tares of lack of discipline. Tares of lawlessness and violence. But we are standing together to say, in the words of George Bernard Shaw, some people see things as they are and they say, why? But others dream of things that never were and say, why not? We are saying, why not come together, educators, teachers, parents, the community, the faith community, and make sure that we make a difference in the lives of our children so that when they come to the end of the field in the evening, at graduation time, particularly in the African American community, it will not be the case that the graduation rate would be abysmally low for us, but we will be graduating on par with those who started in the field early in the morning. So what are we going to do about it? We're going to make sure that we keep things going by having after-school tutorial programs. Back on track, students of promise. In public housing, there are tutorial sessions. We're going to make sure that there are wraparound services for parents who are challenged with keeping pace with what they need to do in terms of supporting the education of their children. We're going to make sure that we have wraparound services to provide safety and security in our schools at the middle and high school levels, that no child need go to school in fear and trepidation, but they will go to school and say in the words of Chaucer, gladly will I learn and gladly will I teach others how to find the way to the good life. So thank you very much, my friends, for proving that we can come together and make sure that we pull those tares out of the field that have no business there. And when we do that, the day will come when all of these children will be able to say, I'm black and I'm proud, I'm brown and I'm sound, I'm yellow and I'm mellow, I'm white and I'm all right, I'm gay and I'm godly, I'm straight and I'm sensible, I'm red and I ain't dead. That is the goal that ought to be ours, that we will keep the tares out of the field of this educational process. And now I present to you our honorable mayor, who indeed uses the bully pulpit of his office to make sure that this city knows that he is an educational mayor, working together with the entire community.
Thank you. Thank you, Reverend Brown. You know, this is great to be here on the first day of school. Fresh faces. The school district is not only awake, but they are eager to provide that essential link that education provides. And I think Reverend Brown is absolutely correct. You know, I wanted to talk this morning, and I want to welcome, of course, Board President David Chu and Supervisor Malia Cohn, whose district we're in this morning. I also want to give a hearty welcome to our superintendent and the 2 school board members that are working very hard in this school district to make it all happen, Reverend. And that is Hydra Mendoza, who's my education advisor, and Emily Marase, who's also on the board. She also serves as our director of our Commission on the Status of Women. We're all here together. I also see Barbara Carlson as our director of our early care education. She and First Five are working in the community with us, but we have a lot of members of our community working together with the school district. Long ago, and I believe it's going to get longer and longer ago, the school district had to struggle by itself. That they saw the state as their challenge, and that this city wasn't there with them. We've learned quite a bit through a lot of tragedies, by the way. Tragedies of failure and of not supporting each other. And I hearken again to President Obama's clear message to us that we are our brother's keeper. We have to help each other out, and we have to make sure we succeed. And so the school district is no longer isolated. In fact, I think more and more you'll see these public-private partnerships that occur, particularly with the school board, the way they are listening to the community and all of the exciting work that we're doing with the corporations in the city, but also the city agencies working together with Superintendent Carranza, our not only Office of Early Care Education, our First Five program, but all of our children's program through Maria Sue's leadership and all the others working together to make sure that we connect up. And so it is that while we invest in what occurs in the classroom, supporting the teachers and the school administrators right here in McLaren, we don't leave it to chance that it occurs only in the classroom. That's what Reverend was talking about, that we have to do it in our public housing settings. We have to do it in our communities of Bayview and all the other communities throughout the city. We have to do it in after school, in preschool programs, in the family home sector. There are a lot of other services that we want to make sure happen. When that tragic incident just a few blocks away occurred this summer, we had to make sure that the kids coming here and to Visitation Valley would be ready to educate themselves and not be traumatized with the things that occurred there. Horrible as it happened, we need to care about them right from the beginning and say that our public health officials who are here talking with the parents, we want to make sure the parents see us here so that they can believe that there is wrap-around services, there is support, not only in tutoring, but other things that happen that will disturb these kids' effort to focus and concentrate on their education, will disturb and misdirect the parents so that they feel maybe this city isn't for them. We've got to recapture that. This is their city. This is our city. We work together constantly to make sure this happens for all of our children. That's how we retain and grow our African American community. We have to give the people who are here already faith that we will be with them in every step of the way. And when you see these classrooms, you'll see how important it is to go from every step of the way. And that we not only when the kids leave the classroom, they are reinforced at home, whether they live in public housing or live in the new housing that we're building just a mile away. They know that our city cares for them. And so we're here not only just to welcome kids on their first day, but to continue making positive announcements. And whether it's working with Reverend Brown and the Black Educators Alliance, or our preschool advocates, or our foundations, or our corporate citizens like Salesforce Foundation and Zynga, who are helping us change the way we have managed and ministered our middle schools, where we know that if we don't do something more, kids and families drop out. We already know that. We are embracing these facts, and we are doing something about them on every single level. Most importantly, that we communicate with the parents in this community, in every community, that this city cares, and we will not rest until everybody feels the equity of the city, feels the success of the city, and we'll bring it right here, right into the Bayview, right into the Sunnydale, and these parents should know that we're all there for them, not only the first day, but the second day, through the middle of the school year, through all of the holidays. We'll be there, we'll be showing up, we'll be working together, right, Rich?
Absolutely.
Absolutely. We'll be there, right, Reverend?
That's right.
That's right. And first day, but we're going to be here, and you're going to see a lot of more announcements as we re-up our effort. We've got some huge things to pass, supervisors, on the ballot this November, and front and center is our children's fund. One of the most important things that we continue doing, that is worth over $250 million each year. And that'll keep kids and families not only coming, but excited about the city. Thank you very much.
Thank you, Mr. Mayor. We absolutely appreciate that you don't only speak about this, you do it. So we appreciate it. And Reverend Brown, we are, I think, going to be joined at the hip, as it were, because we're absolutely in agreement that we are going to be working very closely together. So get used to the three of us. You're going to see us quite a bit. But I would like to take this opportunity to invite Supervisor Malia Cohen to come forward and say a few words. Supervisor Cohen.
Thank you. Happy first day of school, everyone. Happy first day of school. This is a joyous occasion that we're here to come together to celebrate the completion of the summer and transitioning from fun play into a more structured academic play. I think we need to take a moment to recognize not only we're giving ourselves a pat on the back here as educators and city leadership, but really need to recognize the families that these children are connected to the mothers and the fathers that got them up, that fed them, that got them psyched up, ready to go for today. And that is remarkable. This past weekend, all across the city, we had a whole bunch of backpack giveaways. And I got to tell you, this morning when I was at Bret Harte Elementary School, it felt really good to look at the new kids, the little kindergartners, first day of school with their brand new backpacks on. Brand new Frozen, Dora the Explorer, I mean, you name it. It was crisp, it was clean, no marks on it. And that really is a symbol of where we are today. We have a brand new slate. Everyone is a perfect student. Everyone has perfect attendance today. And it is our job as leaders in the community to continue to protect and to ensure that they are traveling down this pathway to success. And this academic success is critical, not only for the individual lives for the kids and the families, but also to our lives in our neighborhood, in our city, and our country. Particularly when you take a moment and you think about just all the strife that's happening all across the world, in the Middle East, in Florissant, in other parts of our city and of our region. And the first day of school really symbolizes a fresh start and a new beginning. So it feels wonderful to be here with members of the clergy, with the city family, with the school district, because we are symbolizing a fresh start as we continue to move forward to bring all of these young scholars to a completion point, and that is a quality education. So thank you to my partners for making this happen. I'm excited, and I'm just fired up. And this is not the beginning. This is not the end of the speeches. We've got a lot of things that we're going to be doing, and we're going to be rolling out this entire academic school year. We're going to be opening up a new school at was it Willie Brown Academy next year? Next academic school year. We're going to continue to beef up our after-school programming, tutoring. You heard, we're not just stopping with in-classroom education, but taking it out and ensuring that there is a teachable moment that we have an opportunity to present to our young people. So thank you for being here. Thank you for being excited. I hope you're excited. Okay, all right. It's the first day of school. Thank you.
Thank you, Supervisor. I'd also like to invite Supervisor David Chu, who is joining us here today, President of the Board of Supervisors.
Happy first day on this warm and sunny San Francisco day. I want to reflect for just a second on what the good Reverend said around tilling the field. We all know that it takes a village to raise every single child, and I want to thank all of you for being that village, from our superintendent to our school board and our school district, from our mayor and his First Five and DCYF agencies, our Board of Supervisors, and all of you who are our parents, our educators. And in particular, I think it's wonderful today we have our civil rights community and our religious communities represented, because we know that education is a civil rights. We know that the quality of education is one of the greatest moral questions of our day. And I certainly know that as San Francisco, we are successful on so many levels. I think that Mayor Lee and Supervisor Cohen and I, we know that the quality of our education, making sure that our most challenged neighborhoods, making sure that everyone is educated, making sure that our African American students receive the best education possible, I think this will be a measure in 2014 to years become and how we do. And so I am bullish about the fact that San Francisco, that has been leading the way when it comes to pre-K and TK and universal preschool, we want to set the model, not just for our state, but for the country. The fact of the matter is California is ranked 49th out of 50 states for what we spend per kid. And I happen to think that is not a good moral place for us to be. That is not a good civil rights position for us to occupy, and I think we all know we can do better. So I look forward to working with all of you who are part of this village to getting it done and moving our students forward. Have a good first day. Thank you.
Thank you, Supervisor Chu. I'd also like to invite Dr. Emily Marassi, who is Vice President of the San Francisco Unified School District School Board.
Good morning, everyone. I want to thank you all for being here on this very special day, the first day of school. I am so proud to be serving on the school board with my colleague, Hydra Mendoza, and others, because we are one of the top performing urban school districts in the state. We have National Blue Ribbon schools, we have California Distinguished schools, and it all starts in classrooms like these. At the preschool level, at the kindergarten level, is where that excellence begins. And we do face challenges, as the Reverend mentioned. We have an opportunity gap with some of our disadvantaged students, and I'm committed, and this board is very committed to addressing those challenges and making this the best school year ever. I want to acknowledge the mayor's leadership in the middle grades and throughout our school system, and making sure that our families choose our public schools first. And really what you see behind us is the legislative branch, the executive branch, the faith-based community, the whole family that helps make our schools great. Thanks again.
Thank you, Dr. Marassi. So with that, let's get on to learning. The first day of school has started, and we look forward to many successes. And I also want to thank the incredible staff here at McLaren for being such great hosts. Thank you so much for what you do, and thank you for welcoming us. So thank you for being here. Thanks.
The Ethics Commission serves the public, city officials and employees, and candidates for public office through education and enforcement of ethics laws. Its duties include the administration of the whistleblower program, investigating ethics complaints, providing statistical reporting, and registration and regulation of lobbyists and campaign consultants. You can tune in for live commission coverage every fourth Monday of the month at 5:30 p.m. on SF-Gov TV.
California Academy of Sciences presents Coral Reef Dive. At 2:30 p.m. daily, watch as a diver suits up in scuba gear and plunges into the world's deepest living coral reef exhibit. Outfitted with an underwater microphone, the diver will answer all of your reef-related questions. For more information, please visit calacademy.org.
I'd like to open an account, please.
Oh, okay. Everyone deserves a bank account. And in San Francisco, anyone can have a bank account thanks to an innovative program, Bank on San Francisco. With Bank on SF, everyone is welcome. Even if you're not a U.S. citizen or have bad credit, you can have a bank account. And qualifying for a bank account is simple. Just live or work in San Francisco and have a form of ID.
Okay.
And that's it.
Okay, perfect.
We started Bank on San Francisco 6 years ago to really reach out to folks here in the city who don't have a bank account. We wanted to make sure they know they have options which would be more low cost, more successful for them than using check cashers.
Check cashing stores can be found all over the city, but their convenient locations come with a hidden price.
Now the fees are kind of off the hook.
I remember one time I came in here and was charged a fee to collect a MoneyGram, which is pretty preposterous.
People who use check cashers, particularly people who use check cashers to cash their paychecks all year long, they can pay hundreds, maybe even $1,000 a year just in fees to get access to their pay.
I don't have that kind of money.
How they gonna pay the rent? How they gonna live?
It's hard, man, when you're out here.
Yeah, I wouldn't have to pay it if I had a bank account.
Bank accounts are essential. They keep your money safe and they help save for the future. But most banks require information that may limit its pool of qualified applicants, encouraging them to turn to costly and unsafe check cashers.
I don't feel quite safe, especially carrying the money order that I get home.
Without a bank account, you're more vulnerable to loss, robbery, or theft. Thankfully, the Bank on SF program was designed to meet the needs of every client, so qualifying for a bank account is no longer a problem.
All right.
Yeah, that's it.
Great, thank you.
Thank you. Even if you've had problems with an account in the past, have never had an account, or are not a U.S. citizen, Bank on SF makes it easy for you to have an account.
Many people don't have a bank account because they might be in the check system, which means they had a bank account in the past but had some problems managing the account and it was closed. That gives them no option but to go to a check casher for up to 7 years. And so we wanted to make sure to help people who are previously in the check system as well have a second chance checking account.
To find the account that's best for you, just follow these 3 easy steps. First, find a participating bank or credit union. Just call 211 or visit one of our partner banks or credit unions and ask about the Bank on San Francisco account. Most participating branches will have this Bank on SF sign in their window. Second, ask about opening an account through Bank on San Francisco. A financial partner will guide you through this process and connect you with the account that's best for you. Third, bring some form of identification. A California ID, foreign ID, or your passport is fine. Now you've opened your account. Simple, right? That's exactly how it was meant to be. You can even access your account online, set up direct deposit, and make transfers. It's a real bank account.
It's been very exciting. We see a lot of people open up a second account. Of course, people never had bank account before, or people who have problem with open up a bank's account, people who don't have 2 IDs, and with minimum deposit. I thought it was really exciting to have those people who we can help.
Well, Community Trust, a division of Self-Help Federal Credit Union, has been a great partnership with Bank on San Francisco because we're able to offer checking, savings, money markets, certificates, and loans to people who might not be able to get accounts anywhere else. So even if you've had a previous bank account at another financial institution, if you had any problems with that account, we can still open an account for you. And so you don't have to go to a check cashing place, which might charge you anywhere from 2 to 10% of your monthly income.
And to help manage your new account, you can enroll in free educational services online. Just visit sfsmartmoneynetwork.org.
There are many benefits that the San Francisco Smart Money Network provides. It's really the one-stop shop for all your financial questions.
With services like financial education classes and one-on-one meetings with advisors, SF Smart Money Network makes it easy for you to learn all you need to know about managing, saving, investing, and protecting your money. The network offers access to hundreds of free financial education programs. To help narrow your options, just fill out the quick questionnaire and you'll be steered toward the programs you're looking for.
We wanted to make sure everybody has a chance to manage their money successfully, keep their money safe, and avoid getting ripped off.
What do you think of it? Doesn't it sound like a cool deal?
It sounds very good, and I think people should try that one.
To find out more, visit sfsmartmoneynetwork.org or call 211 and ask for the Bank on SF program. No more hassling with these expensive check cashing stores. Now you can have a bank account. Let Bank on San Francisco help you open one today.
The airport. It brings to mind visions of travel, romance, excitement, and gourmet cuisine. On this episode of Quick Bites, we're at San Francisco International Airport to discover the award-winning concession program that is inspiring imitators around the world. SFO serves more than 40 million travelers a year, and lots of them are hungry. There are more than 69 restaurants at SFO to choose from, and nearly all of them are branches of local restaurants, bars, and cafes. That's right, even this foodie town's airport is a dining destination. So tell me a little bit about the food program here at SFO and what makes it so special.
Well, we have a wonderful food and beverage program here at SFO. We strive for sustainable, local, organic produce. Our objective is also to be a zero waste terminal and also bring in the best food of San Francisco to our passengers.
I like the sushi joint down there called Wakaboo. It's my sushi is my favorite food. I just beg my parents every day to go to sushi.
The eating options here are fabulous. Definitely better than Los Angeles Airport. 1,000 times better than Dugway.
I had a double cheeseburger with bacon, a fat burger.
I always get the udon. I really like the udon.
My wife is gonna kill me because I'm supposed to be on a diet, but hopefully she won't get to see this video. So.
It totally is a San Francisco experience because there's so many different people and different nationalities in this town. So to come to the airport, everyone can have what they want. Everyone.
Is San Francisco's program modeled after other airports, or are we sort of pioneering some of these concepts that you're talking about?
We are.
Good afternoon. We are back from recess for this special meeting of the San Francisco Ethics Commission. We were about to begin finding and recommendation 12. a couple of things. I want the record to reflect that Commissioner Rennie is excused for the afternoon. And also, we've been informed by SF.gov TV that the touching of the microphone at the podium is causing a lot of noise for viewers on TV. So please, I understand if you have to adjust it for height, but try to avoid otherwise manipulating the microphone. Thank you. Finding number 12. Any comments or questions from the commissioners? I understand that number 12 was not directed at the commission and perhaps is better addressed by the executive director in any event. So I would propose removing the findings and recommendations, since this really does, it was addressed to the executive director. I would say that I think the recommendation for what the director should do, i.e. notify the departments and see if we can ensure compliance, is a good thing. And I would hope that that's what the director has in mind.
Mr. Chair, again, I understand I don't quite understand why they would address something to the executive director, who is an employee of the commission, and this is the civil grand jury looking at the commission. I think that in terms of the propriety of the responses on the part of the commission with the civil grand jury, the responses should be between the commission and the civil grand jury, not by an employee of the commission to the civil grand jury. It's just a matter of protocol, and it also adds to the unfortunate criticism that is also often being made, which I don't agree with, that by some members of the public, and I think they're totally wrong about this, that the commission is run by the executive director. That's not true. We shouldn't do anything that fosters any kind of indication of that. And certainly in terms of a discussion between a body as important and as a civil grand jury regarding the business of this body, I think the response should be by the commission.
Commissioner, the commission has been asked to respond to the large majority of these findings and recommendations, but not all of them. And in 13 cases, they have asked for a response from the executive director. And I don't believe I have a choice of not responding when they've asked for a response directly from me. I don't believe it's happened in past reports, but it is in this one.
Well, I disagree with that. I think that...
Well, you disagree with that? Who they asked it from?
Let me say what I'm... Let me finish.
Okay.
I haven't... Okay. You'll get the answer if you'll wait to hear the rest of my sentence. I disagree with that in regard to the fact that you do not have an option to respond. I think it is improper of the civil grand jury to make an inquiry relating to that goes to a particular employee of a department. That if the civil grand jury has a question or has some information that it wants from the department, it should seek that through the a query to the department and a response to the department. And I think that in regard to the specific questions specifically addressed to the executive director, I think the commissioners, we as commissioners, should instruct the executive director not to answer those, but to have the answer be given by the commission. I just think it's a violation of protocol by the members of the civil grand jury who are looking at a department to go ahead and try and address matters directly to an employee of that department. And it's also an internal problem for us, this department, as I've indicated, in terms of the whole manner in which the commissioners and the executive director of this department carry out their functions. So I would say, out of respect for the civil grand jury, we should answer the questions. We should answer the questions, even if in terms of answering them in the words that Mr. St. Croix would answer them with, if we choose to do that. But the answer should be that the commission responds as such, not the executive director responds.
Other comments from the commissioners?
I just want to say I'm very much in agreement with that, and we may very well, as Commissioner Keene did say, choose to use the words of Mr. St. Croix, but this is the governing body. There are discrete responsibilities and functions that the commission holds, and I do believe that it would go a long way that we take almost a unilateral approach to this, that we always respond as the commission. We respond as the governing body to that particular department. I was actually going to make the recommendation that we, if we do respond to finding number 12, that the commission would instruct the executive director to direct his staff to notify all departments to remind officials and employees to follow the requirement and ensure such postings are easy to locate on departmental websites. That's generally the protocol when you have governing body.
I would,
Mr. St. Croix?
If you're going to adopt this language, the second sentence for finding 12, I've had some conflicting advice on the interpretation of that section, and probably be best to delete that sentence.
The sentence, the Sunshine Ordinance section cited in the report does not apply to departments, only to individuals?
Correct.
I would welcome the views of the city attorney or the staff on Commissioner Keene's and Commissioner Andrews's questions about whether it's even appropriate for the grand jury to direct inquiries to an employee rather than the commission, and therefore whether the commission should respond to everything as asserted.
Deputy Executive Director, I'll defer to the city attorney on this, but I know that the governing provision is in the penal code, and as printed in the actual grand jury report just says the list of public entities that are required to respond to the presiding judge. I don't have the full language in front of me, but I don't know if...
I think that says it all. A public entity, an individual is not a public entity. We are the public entity.
Jesse Minari, I just would want to definitely see the actual language, which I can look up right now, because this is just sort of a rewrite or a brief summary here in the grand jury report. I don't know if you have.
Yeah, so in my experience, at least in my own experience, I haven't seen many civil grand jury reports where they seek both a response from the department head and the department or commission itself. Perhaps members of the civil grand jury in attendance can shed some light on that. They may have different experiences about and can speak to whether that's a regular practice. And certainly I can also just, can see if there's anyone in my office who's had experience with this before. I'm happy to just sort of see if I can find an answer in short order, because this seems to be a more global question that wouldn't preclude the commission from going forward and sort of going through the rest of the findings recommendations. And I can see what I can find out the next little bit of time.
And I think the general recommendation that the commission respond to the findings, regardless of whether the executive director needs to separately respond or should separately respond, that perhaps you can help us figure out. But it sounds like the commission wants to respond to the findings as a commission, and I certainly understand the rationale for that and think we should do so. The separate question of what the executive director, how or if the executive director responds, I think it would be helpful to get input. Mr. Shen.
Sure.
Looks like it does.
We don't have to figure that out today. That's right.
This isn't, but that's
Okay. Any other changes to recommendation 12 other than striking the second sentence of finding 12? Is there a motion to adopt finding and recommendation 12 as amended?
So moved.
Second?
Second.
Public comment.
Ray Hart, Director, San Francisco Open Government. One of the problems I have with some of these issues are that we're talking about the Sunshine Ordinance, the Brown Act, the California Public Records Act, laws that have been in place for more than a decade. And we're going to send out another memo to the departments to tell them to follow the law. I mean, how many, Einstein said it perfectly. The best definition of insanity is doing the same thing repeatedly, expecting a different outcome. And yet I hear that over and over again. We'll send out a memo to the departments to tell them what they know they ought to be doing anyway, and we know they aren't doing. How many times do you send out a memo to a department and tell them to do something or not to do something? They ignore what you say, and then you simply say, let's send them another memo. What did they do with the prior 5 or 6 or 7 or 10? It begs any sort of common sense to simply say to departments, obey the law. They know what the law is. They have specific people who are trained and designated to ensure that the departments follow the law. The individual department heads have a responsibility to ensure that those people carry out those duties. And that's why when I file sunshine complaints now, I file them against the department head. Because under the law, they're the only ones who can be held accountable. And bottom line is they are accountable. I don't care who does or does not do something in your department. If you're the department head, you are responsible. It must be the 12 years I spent in the Navy where if you ever walked into a board of inquiry as a captain or a commander or anything and said, well, it was somebody under my command, I'm not responsible, they would laugh you out. In fact, they would find you in violation just for saying it and then make it very clear that, no, you're responsible. If they did it under your watch, if it happened under your watch, whether you knew it about it or not, you were responsible. And the same thing goes with these departments. They know these requirements exist, and we didn't have a chance to talk about 11 or 10 or the other ones. Some of these are the same thing. We're reinventing the wheel, telling a department you have to keep records and expecting that they do so with some sort of level of consistency. You know, it can't be this arbitrary thing where each department decides we're going to keep emails, we're not going to keep emails, we're going to keep this type of email but not that type of email, and getting into an argument about whether private emails on a private account is before the Supreme Court begs the distinction that public computers with public records have certain requirements and they ought to be same from department to department. And the citizens shouldn't have to be trying to figure that out. The department should.
All in favor of the motion?
Aye.
Aye. Opposed? Hearing none, it passes 4-0. Comments on recommendation 13? Commissioner Keene.
Yes, Mr. Chair. In regard to recommendation 13, the grand jury has asked us that, said that all violations of department statements of incompatible activities should be disclosed to the Ethics Commission and posted on the Commission's website. In regard to the finding that we have as to why we cannot implement that broad mandate, I agree with that. It's just too broad and gets into conflicts with many overriding rights of privacy and confidentiality that have to do with other aspects of California law. relating to employees and disciplinary matters. So it's not something, it's something we simply can't do. If it were more narrowly fashioned, maybe we could. Following up on that, though, in regard to the next sentence after that, in terms of recommendation 13 will not be implemented, I changed the language in a couple of respects. One, in terms of some of the earlier changes that I made this morning, Mr. Chair, before you were here and were adopted by the other members of the commission that are in line with the discussion we just had, where it says the commission and the director concur. I would take out the word director and put the commission's position is that this cannot be implemented when it violates employee privacy rights. I would just change the sentence to that. The other thing I would ask, Mr. Chair, is that in regard to, down at the bottom of the page, there is a statement in terms of trying to justify why we should not do this, where it says, finally, it is not even clear that the Ethics Commission has the authority to make each department automatically report episodes of confirmed misconduct as a matter of course. I move to strike that because, one, it's unnecessary, and it too is too global. It's talking about us, just any kind of prohibiting us from making departments disclose and report any kind of confirmed misconduct. I think that goes too far. I know it's saying it's not even clear, but we don't need to. Don't need to say that. We don't need to concede that. We may be in a situation later on where we're going to be asking other departments to report particular items of misconduct that are not precluded by state confidentiality and constitutional confidentiality rules. And I don't think we want this sentence coming back to haunt us later on.
Any other comments on recommendation 13? I concur with what you've said, Commissioner Keene, as well. Is there a motion to adopt finding and recommendation 13 as amended by Commissioner Keene?
So moved.
Second.
Public comment?
Commissioners, Ray Hartz, Director, San Francisco Open Government. I agree with Commissioner Keene in the sense that just having a blanket, we can't disclose this stuff because it might violate privacy laws. No one has asked anybody to violate a privacy law. Obviously, if the law says you can't disclose something, then you can't disclose it. But if you look at the paragraph on page 9, second to the bottom, the categories not exempt from disclosure are 1, personal dishonesty, misappropriation of public funds, resources, or benefits, so forth. I'm looking at the case that we had at the FPPC against the city librarian. There would be absolutely nothing to prohibit putting on the Ethics Commission website the fact that he was found to have perjured himself 3 consecutive years. He admitted to that. He admitted that he got $5,000 a year from the Friends and then filed a statement of economic interest saying he got nothing from the Friends. And he filed amended statements. Now, that's all a matter of public record. So we're not disclosing anything that's a personal or confidential information that by law is restricted. We're talking about posting something on the website so that the public can know that a public official broke the law, did so with impunity, took $15,000 worth of beneficial items to him, trips and hotel accommodations and so forth, and his penalty, $200 a year fine, a $600 fine. And as I've said before, and I'll say it again, if you want to offer me that deal, I'll take it any minute. Give me $5,000 worth of free stuff a year. Don't tell anybody. Let me lie about it. And then if I get found out, fine me $200. Sounds like a good deal to me. I think every member of the city of San Francisco ought to know that that's what a department head of this city did. And in the same effort He then avoided his responsibility to see where the $60 million that the Friends raised went. Then he went before the public and lied at Library Commission meetings by answering every time he was asked by a library commissioner, are they on track in meeting their commitments and their goals? Oh yes, everything's right on track. And then you spend 2 years finding out that he had no idea because he didn't have a damn record to show how much or in what form that money was spent. My experience is for at least 6 years, they raised more than $4 million a year, spent an additional $2 million plus out of the reserves, and out of that $6 million plus a year, the library got about $375,000. And even that is hard to substantiate. So basically, what we're talking here is putting on, so that the public knows, information that is not prevented from disclosure by law.
A couple brief points. There, in the response to recommendation 13, there's reference to the Good Government Guide, and I think there's a general consensus that this is not really, it's sort of generally advisory, but it's not really a source of law. It doesn't really kind of do the level of analysis that you'd usually be looking for. And you do list the categories not exempt from disclosure, and I don't really see why you can't ask departments to report violations that fall into those categories to the Ethics Commission. Thank you.
Any further comments from the commissioners? I take it that the challenge with asking the departments to self-report those that would be exempt is that it would require us to analyze them separately anyway, and that we wouldn't have any sense that all of the ones that really are disclosable are being shared by the departments. Is that generally the concern? Although I'm not sure there's really a problem with asking for self-reporting. I mean, if they report and we disagree, unless you're getting a deluge of incompatibility violations or SIA violations, what is the burden that we're really worried about?
Well, we can ask them to report. The question is how often do we have to repeat asking them, and how do we know? I mean, some might decide to do it, some might not, some might partially report. We just don't know what we're getting. I think it's going to be a lot of work to keep on top of it.
Mr. Chair, yeah, I think it more goes back to some public comment earlier made, which is if there's not necessarily a consequence built in, then you're spending a whole lot of time on monitoring and remonitoring and just basically not getting the information that you need. So unless we're all willing to design some kind of consequence for failure to report, after we've defined how often they should report, once a year, a comprehensive submission, or maybe some of them need to be more timely than that, I don't know. Unless there's a consequence, we just find ourselves having the same conversation of how many times can you send out a memo and how often are they going to respond to it, and how does that affect you? How does that affect your effectiveness in being this body and carrying out our work?
I mean, here I think the consequence would be that it would be publicly disclosed, which I think is a real consequence. But I also understand the skepticism that they're going to disclose at all, given the legal risk to them of parsing out this language. So unless we can require it, I see that there would be probably disparate effect. All in favor of the motion as made by Commissioner Keene?
Aye.
Aye. Opposed? Hearing none, the motion passes. Can we take 14 and 15 together, as they both relate again to Form 700s? Any comments or questions relating to 14 or 15? Commissioner Keene.
Yes, Mr. Chair. My comments will relate only to 14. And in regard to my disagreement with our proposed recommendation, it has to do with recommendation 14B of the grand jury, which says the Ethics Commission should recommend dismissal for any officer or employee who fails to file 90 days after the deadline. And we have as our proposed recommendation that it not be implemented because this is outside of the Ethics Commission's jurisdiction. Under the state law, only the FPPC can conduct enforcement matters regarding Form 700. This would not be an enforcement matter for us to recommend something. We're not purporting to say that we have the power to enforce anything. We're just saying to whatever that wherever someone has failed to file the form within 90 days, we recommend that they be dismissed. Our recommendation can be ignored and may well be ignored in many instances. So the reason we give here that somehow we can't do this because we'd be conducting enforcement, that's not enforcement. Recommendation is not enforcement. So the reason doesn't make sense. I think it's a good idea, and I would move that we adopt the recommendation of the grand jury that we recommend dismissal for any officer or employee who fails to file 90 days after the deadline. I think that's, in terms of this public disclosure, someone who's had 90 days has been informed by us after 30 days and has been informed with a couple of follow-ups. If they haven't done it by 90 days, then they've shown contempt for the transparency that's supposed to exist in San Francisco government, and that kind of contempt should be disciplined. They should be dismissed. So my motion would be that we adopt the recommendation 14B as proposed by the grand jury.
Commissioner Keene, who do you think we should recommend it to?
I think in regard to the particular officer who's involved, we would look to see under the charter and under the ruling law which would be the appropriate body that could remove that person, whether it would be the Board of Supervisors, whether it would be the mayor, or whether it would be the head of some department, and whoever the appropriate officer or body was that could remove that person, we make the recommendation to that individual or body.
So I'm not against sending something to the appointing officer or the entity who has the power to remove. I'm just not sure that in every case someone who's failed to meet the 90-day deadline deserves dismissal from office. So I would propose modifying Commissioner Keene's amendment to perhaps notify the officer or appointing body that this person has failed to file after 90 days, which is a violation of the rules. But to suggest, in my mind, I would first of all like to make recommendations that I am always comfortable with, and I guess I wouldn't always be comfortable with recommending dismissal.
Well, let me take, Mr. Chair, if I may, let me take your language as you first stated it, that you would not be comfortable with automatically dismissing someone who has not filed the form within 90 days. That's not what we're doing. That's not what would happen. Would happen. So you don't have to worry about that. You can be serene and comfortable about that. Our recommendation is not going to have that effect. It's going to be our opinion that this is something that we consider so important that the person should be dismissed. We're not going to make the ultimate. If there are equities involved, which is implicit in what you're saying, then let the equities be dealt with by the particular body or entity that has the power over that individual to dismiss or not dismiss. I'm sure we can give a certain amount of deference to our fellow departments and other people in city government to exercise that deference and discretion wisely. Our action isn't automatically putting the guillotine down on someone, but I think it's a statement, a strong statement that is merited by this body in regard to the fact that someone would have ignored filing the Form 700 for 90 days. But we're not shooting anybody just off the bat.
Commissioner Andrews?
So under Commissioner Keene's proposal, so is there a scenario by which we would not make that recommendation? Interaction
no,
in the
there's
hospital
not.
for
According to
treatment.
the short answer is in regard to the proposal I've made, which is adopting what the grand jury has made, there isn't. We would just do it in every instance where we see that the person has not filed within 90 days. Now, what we could do, if my colleagues would be more comfortable, put in some language to the effect that we would make that recommendation unless we had heard information from the individual involved that we believe would mitigate or excuse their not filing it within 90 days. We could add that if we wanted.
Can I respond to that?
Yes, Commissioner Andrews.
So I was wondering if we could do, as a friendly amendment, a hybrid of the late filer, the person who fails to file, that in 90 days, that a letter immediately be sent to the official or body, letting them know that they haven't filed, and that at our next regular meeting, if they haven't filed within that 30 days, that it will be at our next meeting that we will make the recommendation that they be.
I would accept that as an amendment.
I like the amendment personally, although my other main concern with this and instances where we make recommendations for which we don't have any authority to really follow through on is that I'm not sure it serves a real purpose. I mean, if the authority can just ignore what we say and if they're getting these letters as a matter of course because people are late on filing, I do worry that we in some ways undermine our own ability when we actually do have authority to enforce things, that those letters similarly get ignored. Commissioner Han?
Well, I'm just thinking if I were the person involved, what about maybe a suspension, recommending that an individual be suspended until such time as they have met their obligation to file Form 700, rather than an outright dismissal. Is that a possibility? Could we amend it in that sense? Commissioner Keene, what do you think?
That would be fine with me. I think the message is the main thing. that the grand jury is emphasizing, get a message out to someone who hasn't done this for 90 days that, look, this is pretty serious. And this flies in the face of the whole desire for transparency or need for transparency in government. And just sort of responding to, if I may, to the chair's statement that, well, we make recommendations and we don't want to, maybe we shouldn't make recommendations if they're not going to be if they're not going to be complied with. I would just refer all of us to the language in the charter that sets up this commission that talks about the commission's duties being to set an example for ethics and transparency and to educate the public and to educate other members of San Francisco city government in good ethical practices. So in that regard, Mr. Chair, I think that we should not be in any way deterred by the idea of making a statement that we believe is appropriate by the idea that, well, someone's going to ignore us. If they ignore us, fine. We made the statement. And it's a statement that needed to be made, and we should go ahead and do it. And that's what the charter set this commission up to do, to be something of a good government advisor to the city and county and to the public.
Commissioner Andrews.
So I like where we're going here, but it feels like what is the implicit in this, or I think we're getting there, is that we're wondering if the punishment fits the violation. Is it too heavy-handed? It could be so unreasonable that that would be the reason why someone wouldn't follow it, compared to not sending out anything at all. So I want that, and that's where I'm kind of hanging out right now. Is it reasonable to request that someone be fired for this 3-month late filing? Is it more reasonable for someone to be put on notice of suspension until you file? In which case, the governing the authority or the entity would be more willing to entertain our recommendation because they would more see it as something in line with the progressive disciplinary action among the spectrum of progressive disciplinary action, all the way up to and including termination. And it feels like we may, for me, it feels like we've gone from 0 to 100 pretty fast.
Well,
I agree.
You obviously can hold that position.
No. As I said, in response to Commissioner Hand, that if we wanted to use a recommendation for suspension rather than fire, that would be okay with me.
But to your point, I would also say, Commissioner Keene, and we should not be afraid to use it. And I think that I would be quite comfortable to move forward each and every time it comes in front of the commission to make that recommendation.
Yeah.
Different than, at least for me, the termination.
So, Commissioner Andrews, Commissioner Hand, did you want to say something?
Well, I guess my question is, okay, if we recommend dismissal, does that really mean that an employee would be dismissed, or it's just our recommendation to the head of that particular agency to dismiss that employee? Because I find that it's hard to believe that anybody's really going to implement that.
They're not. No, that's where we've been. It's going to be just our recommendation, but our recommendation should, we would hope, carry some weight, that we're not just a voice crying in the wilderness, and it's an observation by the city's ethics commission that something has been done here that violates ethical conduct. Whether or not the person gets suspended or dismissed, we don't know. We can't affect that. But we've made the statement, and I think it's an important statement to make.
So as I understand the proposal from Commissioner Andrews, it is that after 90 days, if a person does not file their Form 700, we send a letter to the office, the the individual or entity that has authority to remove that person or discipline that person, and say that, within 60 days, the Ethics Commission will, if they don't file, we will make a determination about recommending further action against
Well,
that
I wouldn't make it
individual?
60. I'd tighten it up and make it 30. I mean,
So
now
within
the
30
body,
days?
The body is
Mhm.
on notice. They're accountable. And I would be more specific, and I would move for suspension. Because there, again, we don't have, there could be, mitigating factors. There could be other factors that we just don't know about. Maybe 95% of the time they were just irresponsible and did a late file. But for the 5% of the time that, as it turns out, they really were hanging upside down in traction and they couldn't sign a document, we would like to leave the opportunity for the authoritative body to respond in that regard within 30 days. To say the moment they're out or...
Would there be an opportunity for that person to come before us? Would we want to hear what they have to say?
I guess that only means something if we were willing to entertain something else other than what the desired outcome we were looking for. I really don't see a need for the person to come before. I would just more recommend that if the authoritative body would like to come before to explain, I would certainly entertain that.
Okay. For myself, I am uncomfortable having a blanket recommendation about a disciplinary action as a matter of course. And Commissioner Keene, to your point, it does not give me any additional comfort that if I would be recommending something I didn't believe on the grounds that I'm not ultimately making the decision. To me, whatever recommendation we give, I think we have to agree, at least unanimous, at least majority agree is actually warranted. And I am uncomfortable having a blanket notion that every time this happens, without actual some opportunity to understand the facts at issue, to then send another letter saying this person should be suspended until they change or certainly dismissed. I would certainly not be in favor of that. But if there's a motion to be made, I think it should be heard and entertained.
The only thing that I wanted to say on that one, and why I'm not moving forward the dismissal and more for suspension, is that I'm looking at this person as an employee. And I suspect in some kind of way we have been or continue to be employees. And this could be the very blind spot that this very good employee has. Otherwise, they're a great employee. They do their job. It's what, day in and day out. And they're just falling down on this particular area. Now, granted, it's a key area. So I would question, obviously, have some questions for the authoritative body. That's why it would be hard for me to move to dismissal, because we are just having a blanket off with their heads for this particular issue and have now thrown out a good public servant for that particular for this particular violation without giving them an opportunity to either explain themselves or have the authoritative body explain that particular situation. So the suspension would basically be you are suspended until you file. Mm-hmm. And hopefully lesson learned.
Can I ask a clarifying question about the proposal? So does that mean it's automatic, or do we then come and vote on it at the next meeting with the understanding that the typical recommendation is...
I would make it automatic. I mean,
make it automatic.
It's not a hard calculus. They can either do it or they can't do it, and they've gone on notice, and they'll respond, and the authoritative body will respond, or they won't. But we did our job, and I don't think we need to complicate ourselves up anymore with if we get to a place of comfort where we say, yes, this is an important piece of reporting, and every time you don't report, this is what happens to you when you don't report. Otherwise, you're a great employee. But yeah, so that's why I'm walking back from the dismissal,
but frankly feel like each and every time that this doesn't happen, there should be a pretty clear and direct consequence for it, in which case we would just move forward.
Commissioner Han?
All right, so thinking about this further, once again, I mean, we're in the position of being a paper tiger. We make a recommendation, whatever it may be, but nobody has to follow that recommendation. So what's the point? There has to be a way to get people to obey or to, to do, in this case, the filing of their 700 forms without something like that. And I don't know what it would be. To me, maybe it's shaming. Maybe every month we should have a press release that goes out naming city employees who have not complied with the filing of Form 700. I think that would, in my opinion anyway, would have a little more power than threatening to suspend or certainly fire. If you're on a list somewhere, and if you can get, the papers, the different media that are out there to carry that notice. Here are the delinquent employees, and explaining what Form 700 is, maybe something like that. I mean, the implementation could take many forms. That's just one thought. But I guess I feel, one of the things that we're constantly criticized for is that we have no power. So then what is the point of implementing something which once again underscores the fact that we have no power? I don't get that. Which is not to say that filing your Form 700 isn't important and that we should find some way to get employees to do it and to comply, but I don't know. I think it's just silly.
Well, I'll say, Andrews. Mr. Chair, I'll say this, and I'm not exactly sure where I'm going to land on this, but I will say that if we're talking about employees that are within departments, sometimes there's a culture within the department, different levels of accountability. And if you want to affect change and you want to affect an outcome, to have a higher accountability, I completely hear and understand Commissioner Hand's point on shaming, and that may work for that particular employee, but it may not address the larger issue of having a culture of a higher accountability of a department, in which case the department head or whomever that particular individual's title is, we get to hold them accountable as well, which ultimately would lead these departments to doing, hopefully, trainings to help their employees do a better job of more timely filing. And that's often what I see, is that it's a culture that possibly lives within any one of these entities that has to be changed, and it has to often be changed at the top. So just a point of observation.
Mr. St. Croix, did you want to say something?
Well, right now, and I'm talking about this year only, we're down to 4 non-filers. So you've spent a great deal of time talking about what we're going to do about 4 people. And I appreciate that you want to do the right thing, but we have an hour and 15 minutes left before we have to vacate the room.
Is there a motion to make any amendments?
Mr. Chair, I move that we implement the that if someone has failed to file within 90 days, we recommend to the appropriate authority, body, or person that that individual should be suspended from city employment.
Is there
Second.
Public comment?
Members of the Ethics Commission, Ray Hartz, Director, San Francisco Open Government. I served 3 years on the staff of Commander-in-Chief Pacific Fleet, and we dealt with human resources issues. And then I spent 14 years teaching management for the University of Hawaii. And one of the things I always made clear to managers who attended my courses was the purpose of taking actions is never to fire an employee. I don't think the intent, and they can correct me if I'm wrong, of the civil grand jury was that any employee be fired. It was to simply take an action which will get them to comply with the law. And as a result, won't have to take any disciplinary action, suspension, otherwise. And really what I'm saying is that if at a 60-day point, you send out a letter saying, here's a list of the people in your department that have not filed their report, their statement of economic interest, and if they fail to do so within the next 30 days, we will probably vote to recommend their dismissal and/or suspension. I would be willing to bet that 95% of the people we're talking about would file that thing within the next week. And that's really what the purpose of this is, isn't it? To get them to file the form. And the departments, going back to Commissioner Andrews' comments, are sometimes the problem. If there is no real atmosphere in that department that filing this is even worth an effort, or even worse, someone very senior in the department doesn't file their own, and everybody else is going, well, why should I? He or she doesn't. That is a real problem that employees sometimes have to confront. So really what I'm saying is I agree very strongly that with the recommendation or with the proposed change, I do not think you should recommend a particular action because the action should be determined solely by the appropriate appointing authority. They should be the ones who consult with the appropriate human resources people, the city attorney if necessary, the unions, the contract, whatever. And to simply say to them, we are going to recommend this if they fail to meet the requirements of the law, I think will be a big enough impetus to that body. And I'll give you a perfect example why I think that. They don't want somebody like Ray Hartz of San Francisco Open Government walking in with a list of their employees' names saying, here are the people in your department that have still not filed their statements of economic interest. And why is that? And why isn't it you doing something about it? And that's really what we're talking about here. Public shaming is sometimes appropriate, but it is also a recognition of the fact that it's the people in charge sometimes who aren't enforcing the rules rather than simply an employee who fails to follow them.
Hello, Larry Bush from the Civil Grand Jury. There's no question that the Ethics Commission has done a much better job at getting people to file in this past year. The fact that they're down to just a few is a strong statement. But I would remind you that this is just the people who file with the Ethics Commission, and it's not including the people who have to file a Form 700 with their department, which is a much, much larger group of people, who you will soon see under the new electronic filing of Form 700s. But it's anybody in a department who makes decisions that affect the budget of that department or who has a potential conflict of interest. What we have seen in the past as we looked at these things are city employees and officials who have outside employment that is a direct conflict with their position in the city. But you would not know that until you could see their Form 700. And you had a case not very long ago from somebody from the PUC who you never saw their Form 700 because they didn't file with the Ethics Commission, they filed with the department. But it turned out that they were accepting money from a contractor that they themselves awarded the contract to. They are not the only one in that example. So that's one of the reasons why knowing what's in a Form 700 is important. You need to know exactly what are the conflicts, and that's not just a state requirement, because here in San Francisco we have a requirement that says city officials cannot be compensated for appearing before other city commissions. And we have certainly had cases where they were doing that. But the FPPC's authority is simply to fine them for being late and not to act on the fact that they were in violation of local laws that said that they cannot be compensated for appearing before other city bodies. That's your responsibility. Well done in part.
Can I ask the city attorney's office whether there are any legal concerns we should have about making recommendations of suspension?
I don't think there are any particular legal prohibitions on the commission making such recommendations, but to confirm, I think the understanding of the commission, they would simply be recommendations. The Ethics Commission doesn't have any individual authority to impose discipline on employees or staff of other city departments or agencies.
Okay. And to clarify the motion, is it for those who file with the Ethics Commission, Commissioner Keene, or is it those who file anywhere?
It's for those who are under an obligation to file Form 700s. Anyone.
Okay. All in favor?
Aye.
Opposed? I oppose. Motion passes. The finding 16. Any comments from the commissioners? (17) We haven't been taking public comment if we weren't going to, unless we were going to make any changes to the particular recommendation response or finding response. Mr. Bush, if you have a clarification.
Just a clarification. The state law is that you have to disclose if you're contributing $500 or more for a trip, but you don't have to say how much more. And you don't have to say if you have any city business at the same time that you're making a contribution to a city official's travel. And we can see that some city officials have very expensive travel and who have contributions from people who do have interests before the city. And in talking to the FPPC with the jury, we certainly had no problem learning that local governments can add additional provisions that specify that you have to disclose a larger amount. You can maybe do like $500 to $1,000 or $1,000 to $10,000 or whatever. And they can also disclose whether or not they have city financial interests. This has become an increasingly important issue in jurisdictions around California. It's not unique to San Francisco.
Okay. Thank you, Mr. Bush. Commissioner Keene, I believe you were about to say something about finding 17?
Yes, Mr. Chair. In regard to finding 17, where the recommendation is that the Ethics Commission staff should collect the official calendars prepared under the Sunshine Ordinance monthly, convert them to electronic form, and post them online, I agree with essentially with our recommendation that that is just too big a task for us to do of every department, and that for us to do it, and for the city attorney and the Ethics Commission to ensure that. However, I think it is a good idea that these all of the departments do collect their official calendars and convert them to electronic form and put them online. So I would, in regard to recommendation 17A, I would change that. I would leave into effect that the resources, we don't really have the resources to do that, or other priorities are wanting already. That's fine. But I would add to that we recommend to all departments that the Ethics Commission recommends to all departments that they should collect their official calendars prepared under the Sunshine Ordinance monthly, convert them to electronic form, and post them online. That they should do it, rather than us and the city attorney go ahead and do it. So I'd put that in the form of a motion. I think it's a good idea that this material be out there to the public, and that it be out there in electronic form. And I think the department should do it. And again, it's only our recommendation, but I think it's a good suggestion by the grand jury, and I think we should recommend that to all of the departments.
Any other comments from the commissioners? Is there a motion?
Yes, I move that the Ethics Commission recommend to all city departments that they collect their official calendars prepared under the Sunshine Ordinance monthly, convert them to electronic form, and post them online.
Is there a second?
Second.
Public comment.
Commissioners, Ray Hartz, Director of San Francisco Open Government. I don't know anybody who's still using a paper appointment folder. Everybody does things electronically. So we're not talking about some people do still, but when it comes to most city offices, do you think they're using a little paper diary that they, then call their boss up and said, oh, remember you have an appointment, or are they sending him an email showing him his appointments for that day? I think it's more likely the other. So I don't think we're talking about any great burden we're putting on a department to take what they are already probably doing in electronic format and putting it online so people can see it. And that's all that's being recommended here is recommend to the city departments that many people in the public have an interest in the calendars of elected officials, department heads, and so forth. And it would behoove and show a spirit of openness to put those out without having people beg for them. And that, unfortunately, is the situation many times people are in. If they want to get information, they have to go to the department. The department refuses to give it to them. Then they go to the task force, and we go, through this constant gyration. So basically, calendars, like it or not, are public records. I should be able to know what my representative to government or the city employee should, how he or she spends their time. I should know who has access to them. And all these things are determined by calendars. And unfortunately, where this really hits the fan is usually around election time. And I'll give you the perfect example. I recently got a flyer from David Campos pointing out that David Chu had met with 597 lobbyists over a certain period. And I read that and I said, 597, that's a lot of lobbyists to meet with. And then I wondered how hard David Campos had to fight to get that information from David Chu's office. I know how hard I would have to fight. I know I would have to fight very hard, and I'd never get it until after the election, which is too late. And that's all that's being recommended in this case is ask the departments to simply take what they have available as far as the schedule goes and post it so that members of the public can see them. And that, again, cuts down on the workload. No more public requests to see diaries or appointment books because they can simply go online and look. I've said this to the police commission many times. If you put a lot of these things online, all these complaints you make about the time and energy you spend and resources you spend complying with public records requests would go away because people wouldn't need to request them. They could simply get them.
All in favor of the motion proposing amendments?
Aye.
Aye. Opposed? Hearing none, that passes unanimously. Let's take 18 and 19 together.
You don't have to respond to 18.
Okay, but does anybody have comments on 18? 19?
Yes.
Commissioner Keene.
In regard to number 19, I don't have any quarrel with what's being done, and I agree that it should be implemented. The recommendation of the grand jury should be implemented and is going to be implemented by us, and that's what we're saying there. However, just as a point of information, and since we have the members of the grand jury here, I do want to ask about the assertion, the allegation in finding 19 that in at least one instance the Ethics Commission inappropriately interpreted the extreme hardship standard to grant a post-public employment restriction waiver. You make that assertion. There is some language here by our staff that there is a disagreement with that. What are you talking about?
The woman that negotiated the arrangements on behalf of the city for benefits for the America's Cup was granted a waiver from post-employment restrictions to work in a leadership position for America's Cup.
And
on grounds that it would, it was like an important career move for her that she would not otherwise be able to take. And this was also a situation where a number of the benefits for America's Cup were being negotiated with Rec and Park, and the chair of the Rec and Park Commission was chairing the America's Cup Committee, and he asked for this waiver, asked to employer and asked for this waiver.
And this is something this commission did, and did
This
it
commission
on
did
the,
grant the waiver.
At a hearing?
At a hearing. And I just think from a precedential standpoint, it's not good.
Okay, that was just before my time, so I was just curious as to what it was. I wanted to know about it. So thanks very much.
Finding 20. Finding 21. Commissioner Andrews.
Can we go back to 20? I was just wondering if we, in recommendation 20B, in the very last sentence, even though we've already made the case for why we will not be implementing, it says further, there is no mechanism in the Sunshine Ordinance to do this. Is that a needed statement? Do we need to say that? Or do we stand strong on just the Ethics Commission does not agree with this finding and believes it is in the public's best interest to have the Commission continue to investigate and hear Sunshine referrals and complaints? Do we need further, there is no mechanism to do it? Are we saying, are we signaling or saying that if there were a mechanism that we would then entertain it?
I read it as just a further, a second reason for why it's not being implemented.
Okay.
Finding 21.
Mr. Chair.
Commissioner Keene.
It's just one thing to put it in parallel with the other language we've had so far, and that is on page 14 of finding 21, up at the top, in that first full paragraph, the sentence where it says, the director notes, I would change that to the commission notes.
Anything else on 21? I had one comment. I'm a little uncomfortable with our response to finding 21B in that I think it's too broad for us to say that there's no basis for the finding about how the commission is perceived. I'm not sure how we could really respond to that. I mean, other people can weigh in on how we're perceived. I don't think we can say there's no basis for that. But I'm not sure that we could also agree that we're perceived in the way that the grand jury has suggested.
You just say disagree and leave it at that.
I would be more comfortable removing that second sentence.
I agree.
I agree.
I'd so move.
Second.
So is there a motion to make the changes as proposed for finding 21?
I'll move, Mr. Chair.
Second?
Second.
Public comment. Sorry, finding and recommendation 21.
Yes, I'd like to comment both on recommendation 20B and on 21. Both of these are really designed to sort of clarify your own workload. And I'm kind of surprised you're not willing to entertain the idea of using an independent hearing officer on sunshine ordinance matters. I think you're getting a case record that's very garbled at this point, and you spend a lot of time kind of trying to sort things out. And I think you'd really be served by having some sort of independent record. And the ordinance says almost nothing about procedure. So there's really a lot of flexibility in the ordinance if you want to, go and attempt to go down that route. As far as a secretary for the commission goes, this does not have to be a full-time position. Somebody spoke earlier about sharing a position potentially with the Sunshine Task Force. I know there's a part-time secretary for the Board of Elections. This is a civil service sort of position. It's a professional position, but it doesn't have to be a full-time position, paid for by you. So it was carefully written not to just be a full-time position. So please be advised.
Can you elaborate on what the difference is between a commission secretary and the executive director? How do you see them operating differently?
A commission secretary is all about helping the commission operate through its meetings. It's not about making any policy decisions. The executive director has a lot of policy and administrative responsibilities that are separate from what the commission does. The executive secretary would be concerned with getting the agenda together, getting all the materials together as appropriate for the commissioners, making sure the hearing rooms are in place, getting the minutes drafted and sort of run by staff and run by the commission, dealing with outside people, things of that nature.
Thank you. Any further comments or questions from the commissioners?
I just wanted to clarify, Mr. St. Croix. So you're the executive director, but who actually does that in the office?
I do.
You do all of that?
Yeah.
Ray Hartz, Director, San Francisco Open Government, and I would actually think that having a secretary who would schedule these things would be an appropriate thing because of my own particular situation, where the last time I had a referral from the Sunshine Task Force to this body, it was announced the day I left the city and was out of the state for 3 weeks, and the hearing was held the day before I returned in my absence. And I think that was done intentionally, and I think there is a clear, in some cases, conflict of interest between a person scheduling things and having a personal axe to grind. I personally do believe that someone contacted the Ethics Commission, told them I was going to be out of town because I had made it very clear to the Sunshine Ordinance Task Force exactly which dates I would be gone, and it got referred. And oddly enough, it sat for 8 months, and all of a sudden, 2 days after it's referred over, it's scheduled for a hearing and heard before I get back. Now, I've said this before and I'll say it again. I don't believe that was just a coincidence, and I don't believe the disingenuous comment that was made by the executive director at that hearing or after that hearing that I was surprised Mr. Hartz didn't show up. Mr. Hartz always shows up for any complaint he files. He does not do this frivolously, and he does not waste his time. He shows up for the hearings that are appropriate. And I think in some cases, these things are scheduled in such a way to prevent a person from actually being able to come and receive the due process of law. I'll be honest with you, I think my rights to due process were violated by this commission, by the executive director, by announcing that the day I left and having the hearing the day before I got back, and making no attempt whatsoever to determine whether or not I actually received notice, simply relying on the fact that we sent notice. because I didn't receive the notice. I think having a separate person who would schedule and let people know what was going on, separate from the staff who has a personal interest in making recommendations about what this commission should decide, is a very, very important thing. It needs to be done so that there's no perception, as I certainly have, that the game was rigged. I've said it before, I'll say it again, it was done intentionally. It was done with the purpose of Mr. Hartz keeps coming here and he keeps saying things we don't like. If we can schedule his hearing while he's out of the state, it will be to our advantage. And a disingenuous comment like, I was surprised Mr. Hartz wasn't here, I think just bolsters that belief.
All in favor with respect to 21?
Just one thing on number 21, Mr. Chair.
Yes.
And again, it's to go along with what we've been doing. On page 14, where it says recommendation 21, our language there, and the third sentence where it says the director notes, that should be the commission notes.
Right. That was part of the proposal.
That's already been done.
Yeah,
Oh, I'm sorry. I'm getting punchy.
All in favor?
Aye.
Aye.
Opposed? Hearing none, that passes 4-0. Can we take 22 and 23 together? Any comments from the commissioners?
Mr. Chair, in regard to page 15, where we have recommendation 23, once again, the parallel language, the Ethics Commission, and take out the words "and the director" are willing. The Ethics Commission is willing to discuss.
Okay. I also had a comment on 22. I would change this to might be implemented or may be implemented. I think the last sentence should also be moved up after that, so that it says the commission will consider using committees on an as-needed basis. Mm-hmm. I think it's a good point raised by the grand jury, and where appropriate, I think we should do that so we can act more efficiently and conduct more business more expeditiously. I think the point that was included in the memo is valid, that with a 5-member board, it's sometimes less necessary, but that doesn't mean there aren't going to be instances when we really could use subcommittees. Any further comments on 21 or 22?
I have a question.
Commissioner Han?
Question about committees. Are we talking about committees made up of the commissioners?
Yes.
Yes.
Or could we appoint other people to be members of those committees?
I don't believe so.
Because we're a very small commission, and we are limited in how often we can meet with one another and when we can meet with one another because of the Brown Act and other sunshine type ordinances. So I don't really know how we would easily implement a committee structure given that there are only 5 people on the commission. So if anyone has thoughts on that, I would welcome them. I'd like to hear them.
We'll take.
Anybody had an idea?
We're going to take public comment on it. We will. But while we're doing 22, I also wanted to do 23. Did anybody have anything to 23?
Yes, Mr. Chair.
No, we didn't. Yes, Commissioner Keene.
On page 15, the first full sentence, the Ethics Commission and the director, take out the words "and the director," and just put in the Ethics Commission is willing.
Okay. I also wanted to delete the sentence, "This is exaggerated," from finding 23.
Chair.
Commissioner Andrews, sorry.
We have here in the finding that it says conflicts have arisen repeatedly, not a number. But in the finding response, we say that we've done this 3 times. Does the civil grand jury agree that repeatedly and 3 times? Did you come up with that same number as well, or was there another number that was greater than 3 that drove this finding?
I didn't have a number, but during the last mayoral race, the city attorney excused himself from quite a few meetings. And I think it was more than 3 meetings. Now, there may have been 3 matters in which outside counsel were retained, but I mean, I realize there's a lot of lawyers sitting on this commission, but in terms of, counsel sitting down in the well, I think there's been times where you haven't had counsel. And at times, there's issues where you're looking at city agencies and city attorneys representing the city agency as well. It gets a little tricky for everybody involved. At the same time, the charter says the city attorney is going to be your attorney. And then the charter also sets up a mechanism in general, for agencies to apply to get outside counsel. So, it's an area there's no quick action on, but I think it's worthy of exploration. And in terms of some of the other cities we've talked to, at least one has outside counsel and is very happy with it.
Any other comments from the commissioners? Public comment on 22 and 23.
Commissioners, Ray Hartz, Director, San Francisco Open Government. And I think to Commissioner Hayon's concern about establishing committee, I don't necessarily hear anybody saying we establish some sort of a permanent committee that has to meet every month, and so forth. It is very appropriate under most rules of orders, including Roberts, to have temporary committees where you identify a clear problem and you say, gee, it's going to be almost impossible for us 5 to get together. Let's take 2 or 3 members, have them on a separate committee. They can meet and deal with this and then come back to us with a recommendation. It's the same thing, I think, similarly to what we were talking about earlier about having a hearing officer. Hearing officer doesn't necessarily have to be a separate person. For example, the police commission, the hearing officers are the members of the police commission. If there is a hearing and there's to be a hearing officer, one of those members is appointed to be the hearing officer. They then come back and report back to the full police commission. So there are ways to work these things around so that you can have your cake and eat it too. And really what it comes down to is some of these things, if you had a subcommittee, it could deal with certain things not requiring 5 of you to get together, which in many cases is very difficult, where the 2 or 3 appointed to that temporary committee could very easily arrange their schedules to meet. So again, these things are not difficult to do if you really want to achieve a purpose. But if you simply start out with the idea that, well, we're going to have to set up this big, complicated mechanism, and it's going to be involved, and we already have so many restrictions on our time, and it's just going to be, that's kind of like henny penny and the sky has fallen. I agree with Commissioner Herr that, leaving it open, that if you decide you want to appoint a committee to handle specific issues, and then come back and report to the full commission, I think that is a very, very appropriate way of handling it. It is also a very efficient way of handling.
All in favor of the changes proposed to recommendation 22 and 23? Aye.
Aye.
Opposed? Hearing none, it passes. I would like, if possible, to take 24, 25, and 26 together, unless there's objection from the Commission. Commissioner Keene.
Yes, Mr. Chair. Once again, in regard to the language at page 16, recommendation 25, in the middle of the paragraph where it says the director notes, I would change that to the commission notes.
Anything else? I have a couple amendments. On 24, on the recommendation, it sort of seems like it's not responding to the recommendation. I mean, this recommendation appears, from my vantage point, to be directed to the mayor and the Board of Supervisors, who should request an annual written report. I would say that if they do that, we should provide it to them. But it's sort of non-responsive as written, in my view. So I would propose an amendment that if the mayor and the board make such a request, that the commission will comply with it. On 25, the recommendation, I think to steal one of Commissioner Keene's comments, I mean, this is sort of apple pie here. I mean, why? Of course, if we had the resources, shouldn't we do the things that are suggested in recommendation 25? And so I would change the recommendation to say, provided with sufficient resources, the commission could and would do the work that do more work as indicated by the finding, or something to that effect. Any comments from the commissioners? Is there a motion to amend 24, 25, 24 and 25 as proposed by Commissioner Keene and Commissioner Herr?
Yes, so moved.
Second?
Second.
Public comment?
Lena Schmidt, a couple of comments on 24. 24, where the grand jury made a recommendation that you should be doing an annual report to the Board of Supervisors. And I just want to talk a little bit about that part. Remember, and Commissioner Keene talked about it earlier, you're also kind of the example of what should be happening and showing what good government is. Ethics, as I've said earlier, incredibly important to the citizenry. They don't get a chance to hear all the requirements that they have voted on, the requirements that have been put in place at the state level or the federal level for ethics in government. The citizens don't really get any kind of report on what that means. And so if you're saying, let the Board of Supervisors ask us and then we'll give a report, remember it's in your charter that you should be doing an annual report. And it's an annual report that would be very helpful to the public that says, here are all the requirements, these are new, these are not new, these are ones we're thinking about for things that may be coming forward. So it can be an important piece of information just for the citizenry. I would ask you again to consider doing an annual report. Everything that we could find, nothing that had been reported to the Board of Supes in terms of the effectiveness of the laws, in terms of what was going on with the laws and what was happening with them. So I'd again say it's probably worthwhile to think about an annual report. Thanks.
Larry Bush from the Civil Grand Jury. Just to clarify, this is not the regular annual report that all departments have to file. This is a special report specified in the charter where you are to report to the board and the mayor on the effectiveness of San Francisco's ethics laws. Clearly, there are issues having to do with the effectiveness of the laws, and they have not been reported. The example is of the March 2008 memo outlining the problems that you found and adopting new policies about enforcement is an example of something that was never reported to the board, never reported to the public, and which completely changed the enforcement policies of the department. So I think that it would be a really good idea to comply with the charter. Thank you.
As Mr. Bush pointed out, this is separate from the annual report that's required of all departments and boards. We understand and we've seen opinion from city attorney that the form of this report is not specified and it can be prepared in a lot of different ways. But we've seen no evidence that's been prepared at all. And we really believe it's a violation of the charter. Now, we did ask the mayor and the board of supervisors to request it, but I think you should think about being proactive on this. I think it's an important statement of policy for the commission to render on an annual basis about how the laws are doing. And it should, provide the framework for changes that you might entertain in the future. What's happening now is you're looking at one little piece of the law at a time, and you're not looking at things in a very broad sense. So for us, this report is really important. And in this response to the recommendation, to say implementation is not up to the Ethics Commission is just, I don't really quite get that. And it's not
to be fair,
necessary.
the recommendation does refer to the mayor and the board making a request.
Yes, but ultimately you must prepare it.
Well, right. If they prepare it, we should. I hear what you're saying. Maybe we should prepare it anyway, but
yeah.
I'm not sure it's fair to criticize us on that particular point given the way it was written, but I understand your point.
Okay.
Commissioners, Ray Harris, Director, San Francisco Open Government. I'd like to say I believe that the prior speakers were all correct. There's nothing requiring you to do something, but there's nothing preventing you from doing something. And as we were talking earlier about the statements of economic interest, wouldn't it be embarrassing if Mr. St. Croix's list indicated that one or two of you had not filed your SEIs on a timely basis? And I think that would give you a very great impetus not to want to be embarrassing yourself or the other members of the commission. And setting this report out, and this is something I say to the Sunshine Ordinance Task Force all the time, if anybody in this city is going to run a meeting in accordance with the Sunshine Ordinance, it ought to be you. Because part of what you do is set the example for every other body, and your whole basis for credibility is whether you follow the things you're telling other people they need to do. You can't have a city department come in and find them in violation of a law that you don't follow and have any credibility in doing so. And especially if they know you don't and can simply say, well, if this is so important, why aren't you doing it? And I found many members of the Sunshine Ordinance Task Force believe that is a very valid and cogent argument. So putting this report out and giving it to the Board of Supervisors and to the mayor on a voluntary basis sets an example for other city departments. We're not going to just do what we're forced to do. We're going to do something which is proactive and something which the charter requires, something the civil grand jury recommended, and as members of this commission, I would hope you would feel is a very important and appropriate thing to do.
Interested in the views of my fellow commissioners, but I am becoming persuaded that maybe we should do a report like this. I could see the benefit for our own, regardless of what the board and the mayor do with it, for us to, on an annual basis, have a good sense of how we're doing with these ethics laws and be able to look back on it on an annual basis as well. Is there any concern by the staff about doing something like this?
No.
I agree with the chair in light of the comments and the concerns and the very valid points expressed in regard to us telling the public and what it is that is involved in ethical matters on a regular basis. We should put out an annual report doing just that. I'd move that we do it.
So perhaps we can amend our response to recommendation 24 then to say that we will provide on an annual basis the report regarding the effectiveness of San Francisco's ethics laws. We need to remove on that?
Yeah.
Yes.
Sorry to interject another thing, but just to be consistent with your prior edits, you may also want to amend the last sentence of the response to recommendation 26. I believe Commissioner Keene has mentioned a few points where references to the director should be removed.
Yes, and also at recommendation 25 as well. Oh, I think I've already spoken to that.
Yeah.
Yep.
Thank you.
Is there a motion to further amend our responses to 24 and 25?
So moved.
Second. All in favor?
Aye.
Opposed? Hearing none, that passes 4-0. Recommendation 27. Any comments from the commissioners? 28. I have some proposals on 28. I would, in the response to the recommendation, I would delete the second sentence and the last sentence.
Where is that?
Recommendation 28 on page 17. I would also delete "as troubling" in the second to last sentence. Any other? Commissioner
I have
Hand?
a comment on recommendation 28. Not necessarily our response, but I just want to say for the record that this feels like a Star Chamber procedure or a game of j'accuse. And I think that, as noted in our response, at any meeting, people, certainly the public, is free to bring up any issues of this nature as it is. But I would be hesitant to make this some kind of formal aspect of commission hearings.
I agree that I don't think we should include that in our formal hearings. Any further comments from the commissioners?
Can you explain what exactly you changed?
Yes. Well, I'm proposing that we delete the second sentence of the response to recommendation 28. I next propose. So I would propose deleting. This is a politically charged and extremely troubling idea. The potential for abuse is astonishing. I would also delete in the second to last sentence of that response, "as troubling." And finally, I would delete the last sentence. Not sure how my fellow commissioners feel about that, or if there's a motion. Is there a motion to adopt recommendation 28 as amended?
I move that we adopt.
Is there a second?
Second.
Public comment.
Commissioners, I'll make this very brief comment. I think the two changes are very, very appropriate. And I would also like to point out that Commissioner Keene and others have done, I think, the executive director a huge favor, because they have taken him out of my line of fire and taken the responsibility and placed it exactly where it belongs, in my opinion, which is on your own shoulders. All of these changes where you take out the executive director says or decides or whatever really lead to that impression that was mentioned earlier that, you are being directed by him rather than you directing him. And I think taking his name and position out of this in all of these cases that have been done has done him a service, and it also really does make it very clear that you accept the responsibility to which you have agreed when you take your position.
Well, with respect to recommendation 28, Congress does this all the time. I mean, this is sort of what legislative bodies do. When things are looking a little, not sure what's going on, let's have a hearing. And there's a lot of ambiguous stuff going on in the campaign finance area and other areas, and there's frankly times where the city family looks like it's sort of scratching each other's back a little too much, and it's worth putting it out in the public and letting people talk about what they're doing, because it's that light of public discussion that clarifies a lot of issues. And the fear of abuse, we're not saying that just because somebody shows up and says you want to have a hearing on it, that you should be compelled to do it. But I think not everything rises to the level of opening a confidential investigation. Not everything is clearly a violation of the law, but there's a lot of things that are unethical that may not be illegal. And you're an ethics commission, and you should be highlighting questionable behavior. I mean, there's so many examples, I don't know where to start. But, I mean, we put in some of the travel disclosures and some of the behested payment disclosures. I mean, these raise questions. I mean, what's really going on here in terms of, why are people giving this kind of money? What are they expecting in return? Is this just how business is being done in this city? And sometimes it's just good to have a public hearing on it. And, you can do it or not do it. You can do it in response to this recommendation. You can decide you want to do it in 6 months. It doesn't really matter. But it's not a star chamber. A star chamber is a closed, kind of secretive hearing where nobody else comes in. This is more of a public forum that we're talking about. And I think there's a lot of instances where the public sees things that are reported in the papers about who's important at City Hall and things like that, and they wonder why they're not registered as lobbyists, what's going on here. And because there's no investigation and there's no ultimate finding, because people have concluded that there's nothing illegal going on, public skepticism continues to grow. And sometimes it's important to put this out there and let people defend themselves as well. It can play in a lot of different ways. So, I guess I just kind of dispute the idea that this is all something that could be totally abused. I mean, I've had to live with congressional investigations in the past. And yeah, they drive you crazy, but, it's just sort of part of life. In terms of 27, when the State Assembly acts on things to amend the Political Practices Act, they at least put a pro forma finding in at the end, in the enacting clause, that it furthers the purposes of the Act. We don't see this with the ordinances at this point. And the pro forma finding isn't that impressive, actually. I think it should be, an actual finding that's made and that details in some specific ways how people think it furthers the purposes of the Act, rather than just listing a bunch of reasons why it makes sense to do this amendment. But anyway, thank you.
Thank you. Further comments from the commissioners? All in favor of adopting recommendation 28 as amended?
Aye.
Aye. Opposed? Hearing none, that passes. Finding 29. Comments from the commissioners? I would invite someone from the civil grand jury to speak on this one. I'm worried that maybe we are talking a little bit past each other between the recommendation and the response to the recommendation.
Certainly. As we looked at a number of the ethics laws and campaign finance laws and things of that nature, and thought about how we interpret them and think about how they're being implemented, we often look to the statements of purpose that were put into the laws and the legislative findings and things of that nature. Proposal J had this concept of restricting what people, in terms of if somebody was getting a public benefit from the city, and this could be a zoning change, it could be a contract, it could be a lot of things, they were restricted from giving campaign donations to officials that could decide on that benefit. So it was an interesting kind of concept. I think from an implementation standpoint, it presented difficulties. But there were a number of findings and recommendations, and I think we listed them in the report. I'm trying to find the right place, and I know we have the whole thing in
27 and
78.
28.
78.
78, yeah. We have the actual ballot measure on 78. So we have a finding that the use or disposition of public assets is often tainted by conflicts of interest among local public officials entrusted with their management and control, that such assets should be used or arranged strictly on the merits of for the benefit of the public and irrespective of the separate personal or financial interests of involved public officials. They make a similar finding about sale and lease of property, conferring cable, trash hauling, and other franchises. And they declare there's a compelling state interest in reducing the corruptive influence of emoluments, gifts, and prospective campaign contributions on the decisions of public officials in the management of public assets and franchises, and in the disposition of public funds. The people who compensate public officials expect and declare that as a condition of such public office, no gifts, promised employment, or campaign contributions shall be received from any substantial beneficiary of such a public decision for a reasonable period as provided herein. I mean, you can go through the definitions and actually what's barred in that, and we're not really saying, gee, you should go reenact this right away. Although I'm sure if it got put on the ballot, it would pass with 80% of the vote again. But I think these findings and declarations are a useful kind of discussion area to think about the purposes of the laws in general and how the laws don't really match up with some of this. And there's certain areas about zoning changes and things like that that really are falling outside the government ethics laws right now. At the same time, Proposal J just dealt with a very small class of elected officials and high government employees and doesn't reach to the levels of people who have to file Form 700s right now. So we're not saying, gee, this should just be totally reenacted, but it's something that needs more public discussion and is worth revisiting, we believe.
And just so I'm clear, and maybe I just had a hard time following this, but what is missing from E that you think we should take from J?
Oh, E was a funny thing.
Okay, but can you just answer? I'm sorry, we're just running out of time. So what specifically is in J that you want that's not in E?
Oh, no, could you rephrase that?
What is not in E that is in J that you think we should implement?
All the findings.
All the findings.
Yeah. All the legislative findings and declaration of purpose were basically removed. And the concept of a public benefit was basically taken away. Proposal E has kind of a complicated story, and I think in the interest of time,
okay,
we don't want to go through it all.
Thank you.
But there was sort of an enacting clause in it to repeal J, and unless you kind of knew the chain of events, there was no way of kind of knowing that was what was going on.
Okay, thank you.
Thank you.
I'll make this short. Larry Bush from the Civil Grand Jury. Some of the things that are missing out of Prop E that were in Prop J would include zoning changes that benefited a particular developer. It included leases. So, for example, when PG&E took a lease over some watershed land at the PUC, that was considered not to be a contract. So, therefore, there was no prohibition on PG&E making contributions to the mayor who signed the lease. It also includes things like gifts of travel money to underwrite someone staying in luxury hotels or flying first class. It didn't include behested payments where you receive a benefit because you get a company to make a contribution to a favored charity or a favored purpose, and that contributor in turn receives a major city benefit. As I'm sure you've seen with Kilroy Realty giving $1 million for the America's Cup deficit, and then within months receiving approvals for 4 additional stories on its building on the Mission Street. There are a variety of those things that also included the private right of action with penalties and so forth. I would point out that while this response says that this was approved by so many members of the board and by the commission, that commissioners have no recollection. There was nothing in the language of Prop E that explained what was being taken out of Prop J, as is outlined very clearly in the Civil Grand Jury report. And a few years ago, we had a proposal that came from the commission to change, allowing the commission to adopt its own rules on political consultants. And what you saw was a unanimous vote of the board to put that on the ballot. And once it was explained to them what was not explained to them in that proposal, several of them pulled their endorsement and campaigned against it, and the voters defeated it 60-40. So the mere fact that you've listed a group of people who endorsed 2003 only speaks to the fact that 2003 was not a good year to pay attention.
I guess my concern with our response is that while I agree it's true that it probably is fruitless to try to readopt Proposition J as written, I took the recommendation as meaning we should look at what was in Prop J and not in E and see if any of those make sense for us.
That is what the jury meant.
Okay. So, I guess question for the staff, what's the downside of doing that? Or is that already addressed in everything else from findings 1 through 28?
I think the major outstanding issue, I guess, is that in its the form that it is in, the Los Angeles Superior Court said it was unconstitutionally broad. No one took that challenge any further. So that's the one legal precedent we have to go on.
Right, but we're not talking about readopting it. I think we're talking about looking at it and seeing if there's anything in there that would be useful for San Francisco that could be drafted in such a way as to not be unconstitutional. And is that, or have we already tried that, or
not that I know of?
Is there any reason not to do it? It's not rhetorical. I just don't know.
Jesse Minardi, Deputy Executive Director. I don't think there's any reason not to look at what's in Prop J, certainly. I do think it does speak to something that Prop E was passed and Prop J then changed, so it is a bit odd going back 10 years, let's say, to kind of revisit the issue. And I certainly wouldn't want, I would think it'd be advisable to look at that as terms of guidance, but in terms of what could be effective with respect to our campaign lobbying laws, et cetera, I don't think we'd want to limit ourselves to considering exclusively Prop J because, quite frankly, times have changed, campaign finance laws have changed, Supreme Court rulings have changed. So I certainly think it would be great to inform our decision-making, but I wouldn't want to be limited just to Prop J itself. That would be my 2 cents.
Commissioner Keene?
Well, we wouldn't have to limit ourselves to it if we, and I'm going to propose this, that for some future meeting, we put on the agenda an analysis of Prop J and Prop E and what was lost from J that was not resurrected in E, and whether or not we want to go forward and perhaps use our own power of 4 members of this commission, putting something back on the ballot, putting something on the ballot relating to those measures in Prop J that were ruled on, were lost because of the Superior Court decision in Los Angeles, and wanting to go forward with those.
And if perhaps the only amendment I would add to that, if the staff thinks that should be part of a larger discussion,
fine. Oh yeah,
that's fine.
Yeah. Feel free. Sky's the limit.
Sure.
Is there a second to that motion?
Second.
Any further public comment? All in favor?
Aye.
Aye. Opposed? Hearing none. I think that's it. Is there anything else that we need to do?
I just want to say a quick comment. Again, I want to commend the civil grand jury on the work that you've done, and it gave us a lot to think about and talk about. And at the same time, I want to be mindful of the fact that we've created work for our staff as well. And I think it'll probably be important for us to at least create, I'm adding more work, kind of a dashboard of what we've made in terms of recommendations today. Because some of these
will grow to be pretty sizable projects. And we've been talking throughout the day. It's been peppered with limited resources and limited human resources. And I want to have a really clear expectation of what we can get done, and maybe even revisit it and a dashboard and prioritize the work. Because again, it's easy to say that we should take these all on, but if you don't prioritize it and look at it reasonably, then we won't get it done.
Commissioner Keene?
Yes, Mr. Chair, I'd just like to put in the form of a motion that the Ethics Commission would like to thank the civil grand jury and commend them for the great and hard work which they've done. They have helped us enormously. They've educated us, and they've moved us, I think, quite positively in our work, and we owe them a great debt. I'd put that in the form of a motion.
Second.
Public comment? All in favor?
Aye.
Aye. Opposed? Hearing none, that motion passes. Again, thank you for all your hard work. I also would like to thank the staff for their hard work. I think we've done a lot of good things as a commission. I do think that some of our disclosure and our website are some of the best around, and I think some of our investigative work has been very good as well. We can do better, and I thank the civil grand jury for helping us figure out how to do that, and I know we have a great staff that's going to do a great job implementing some of these changes, so thanks to all. Unless there's anything further, the meeting is adjourned. Motion to adjourn.
Motion to adjourn.
Second.
All in favor? Public comment? All in favor?
Aye.
Adjourned.